Obliged.
The content of the response I beg to mention item number 23, Lordship. Secondly, adjourn from 1.
Interim, no extension. Done. What do you say?
Out of state.
So what? He knew that the interim was till today. Want it, I can have it after 4 weeks. Going to extend the interim. Let's see, other side will obviously ask for affidavit. Why you are asking that? If file affidavit, then take the advantage of the counsel from the income tax department who always takes time. Isn't it? That's when the matter reach.
Please, Your Lordship. Lordship, in item number 6, an additional affidavit we have filed yesterday. It may be called
16.
6. Item 6. Motion.
Take 6.
Mention item number 19 for admission.
Huh? What?
Item number 19, matter.
Adjourned. At the request of the learned counsel for the petition, a matter stands adjourned to after 4 weeks.
Lordship, the affidavit by the chief engineer is being filed today.
Hmm?
An affidavit by the chief engineer is being filed today.
Will be filing?
Yes, today itself.
So we'll take it today.
At-
Bring it by 2 o'clock.
My lord, petitioners have a patta plot of land at Lonka, my lord. On the said land, revenue, my lord, railways are constructing 132 kV transmission line over the plot of land. And in this regard, my lord, survey was also made. At the time of survey, my lord, they have stated, my lord, the poles are constructed near the wall of the land. But now they are trying to erect the same in the middle of the plot, which will cause, my lord, maximum damage to the petition.
Then you will be entitled to compensation.
My lord, actually, at the time of survey, they shown us that they should have to,
No, they must have, these are being done under which act?
my lord, as per my lord 10D of my lord, Indian Telegraph Act, minimum damage can be caused. But if they erect the poles on the middle of the land, then my lord, whole my lord land will be damaged. My lord.
Now, pursuant to the notice of 11.8, did you reply?
Yes, my lord.
Did you reply?
Not reply. Initially, we don't have any objection, and thereafter, my lord, they have intimated us to submit our bank statement and other relevant.
Hey, this notice was categorically given to you. Why didn't you oppose that? Look here, I am not, my land should not be involved out there. Now, if your land is somewhere involved, then file your application under the Telegraph Act for the district judge claiming compensation.
And it
It was an opportunity given to you. You have not exercised that. What to do?
And in fact, if Lordship may kindly look into case 23, I have made representation also before Deputy Commissioner, my lord.
Did you say?
Page 23, my lord.
Published that for installation of it so and so has been determined the appropriate location for erection. Subsequent, instead of such place against the surveyed place, action is being taken up for installation of it. Therefore, we request you for erection of the location determined by the Lakmandal. How is it? This is not going to happen. Oppose it. You should have opposed that. Why haven't you brought in the entire document? Where is the entire Telegraph Act?
Yeah, I enclose the relevant portion only, my lord. That is 10D. If lordship may kindly look into last page, my lord, page 27, lordship.
No, the entire one. Well, it can bring on record. Next date you bring the entire Telegraph Act. Is the matter on Monday?
Can it be possible on Wednesday?
Huh?
Wednesday.
Wednesday. 7. Huh? The request of the learning.
Okay.
Yes.
Lordship, the petitioner before your lordship is a lawful owner of a plot of land, your honor. At revenue circle, not what, your honor. Lordship, I was the owner of the plot of land. But due to some financial crisis, lordship, I have acquired an amount of financial help from respondent number 6, lordship. Lordship, that where the respondent number 6 has taken some blank documents, signed some blank documents from me, and he has acquired prepared a false and fabricated power of attorney, which has been mutated under the name of in the name of Srimati Mamta Jain and Srimati Priya Bhatta. The Jamavandi annexure is at page number 14, your honor, lordship.
Yes.
Lordship, we have tried to apply for the certified copies of the illegalities, but there were no response from the respondent number 3 and 4, lordship. So we have went there and applied, and there the only response we got is that apply online, apply online. So, but there was no response.
Where is your application online? When you apply, there is always a receipt given, no?
Yes, but there was no receipt, your lordship.
Absolutely not possible. When you apply, obviously a receipt is given. Where have you applied?
No, lordship, they say that we should apply online,
Then why
lordship.
you are not applying online?
But we have applied.
Where? Where? Where is your receipt?
The receipt is, we didn't receive
It
the,
is at home.
yes, lordship, the,
Tenant counsel appearing on behalf of the petitioner submits that he would like to file an additional affidavit, bringing on record the receipt upon making application for certified copy. If so, for the certified copy of the deeds in question was applied online. Is the matter when?
lordship, after we, lordship.
Is the matter on 9/9? 9/8.
May I please, your lordship? My lord, the petitioners before your lordships, my lord, with the horse pilgrims during the horse 2023, my lord. Now their case is that, my lord, they paid, my lord, the airfare for international chartered flight, my lord. But ultimately they were taken by normal passenger flight, my lord. And for doing that, my lord, there has been an excessive money, my lord, that will, my lord, come out from the change of the flight, my lord. Now, This honorable court, my lord, first a similar order, my lord. Page 53 to 70, my lord. Relevant.
The
68
same
to
matter came up before me on that date. I should notice.
Again, my lord,
notice.
two writ petitions. One I have annexed and another writ. Two writ petitions, my lord, disposed of by this honorable
Very
court.
good.
Directing the respondent authority, my lord, to consider the representation filed by the writ petitioners, my lord, pursuant to the section 42 of the First Committee Act, my lord. Page, my lord, 68 to 70 relevant, my lord.
There are two similar matter, my lord. One is Abu Bakr Siddiqui and this one. So I pay for listing along with this one.
We issue notice in this matter. Notice need returnable on 28th of August 2024. And so you appear for 1 and 2, na?
One.
For respondent number 1. As regards to respondent number 2. Aji kitai. Returnable on 6th of September. Shouldn't be the Mr. So represents the respondent number 1. Accordingly, extra copies of the said petition as regards the respondent number 2 is directed to take steps by way of registered as well as usual. The petitioners herein are aggrieved by the inaction on the part of the in not refunding the excess amount which was collected by the said respondent, what is more particularly the respondent number 2, on account of the direct chartered flight from Guwahati back to Asian Point. That regard, the petitioner had also submitted a have not been disposed of till date. So on the returnable date, on or before the returnable date, the respondents herein are directed to file their affidavit bringing on record their stand.
Lordships, I appear for the petitioner. It's the same matter which my lordships have heard in detail yesterday.
Same order.
Yes, same order.
Yesterday, what did I say at last stayed? I
Yes,
won't
my lord.
say, I will say that no coercive action in pursuance to the assessment order.
Yes.
Because if I stay it, then the question would be, there are many other implications which will be involved.
This is matter relating to central government. This matter relating to central government. State is not.
Remove that, only central government. State government is not there. Government, yeah. Order to avoid that that no coercive action shall be taken on the basis of assessment order so passed, impugned in the instant proceedings, dated
It's 26/4/2022, page 73.
2000.
26/4/2020.
26/4/2024. The next stage.
Right.
Oblige.
Second DI. Ali Swaljani did.
Wait, please, my lord. My lord, this is the second round before this court. The first round, my lords, my mining plan was revoked, and I was forced to come to this court, challenge the action of the government, my lords, the IBM, for the revocation. The order by which this whole exercise was suspended is an order of 8th of March 2022, my lords, which is Annexure P27. Page 214, my lords.
Each
214, Annexure 27. P27.
there's some order pass.
Yes. Because, my lords, the revocation was carried out without notice to me and without following the principles of natural justice. And for other legal, my lords, grounds which we had taken eventually, my lords will see at page 219.
So your revocation was suspended.
Suspended, my lords. That was the first round. Now, what has happened, my lord, is pursuant to this, based on the same exercise, my lords, my mining lease, which was executed, my lord, that grant, my lords, that has been cancelled. My lords will, and also, my lords, please bear in mind that this entire exercise was again carried out without notice to me. I was not even aware of the entire exercise. In an affidavit which is filed before this court in this particular matter, which my lords had just seen, there we get to know that this exercise has been done. Please see the affidavit first, my lords, and then the order. The affidavit, my lord, is at 240, Annexure P31. And my lords will directly come to page 246.
Yes.
At 246, my lords, after para 5, the second part of para 5, this is what is disclosed to me. And it also says the cancellation orders in respect of the mineral concession holders, that is the petitioner, were dispatched through speed post at the correspondence address of the petitioner as available in the office, but the letters were returned back unserved. Now, when I get to know about this, when I'm served with this, I send them series of letters, which are from, my lords, page 248 onwards. Annexure P32 onwards, saying that this is what I've been informed, but I've not received any cancellation, formal order of cancellation. So please send it to me. So after 3, my lords, reminders, eventually what I find is a letter which is sent on, my lords, 4th June 2024, which is Annexure P35.
Page?
Page, my lords, 251. And referring to the earlier letter, my lords, of 15th of February 2024, which I will come in a moment, my lords, I am to inform that your cancellation order in respect of grant of provisional mining lease for graphite block over so-and-so, Talia Upper Subansiri district, was dispatched through speed post at your correspondence address available in the office records, but the letter was returned back unserved. In view of the above, I am to forward herewith a copy of the cancellation order, my lords. Now, please see the cancellation order, my lord. At page 222, page, my lords, 222, Annexure P28. My lord has that?
Yes.
My lords will see that this is an order of 14th of July 2022 itself. And my lords will please see the subject. It says cancellation of provisional mining lease in respect of graphite deposit over the same, my lords, Subansiri district. This is the block, my lords. Now, please see para 2. Whereas a provisional mining lease was executed on 29th of January 2021 without having approved mining plan in respect of graphite deposit over so-and-so, this is the petitioner, my lord, in favor of the petitioner. Whereas provisional mining lease was executed subject to fulfillment of statutory clearances and therefore not in accordance with the prerequisite conditions as prescribed under 5(2)(b) of the MMDR Act 1957, therefore liable for cancellation. In view of the above and in view of the MMDR Amendment Act 2021, the provisional mining lease in respect of the graphite block over so-and-so to the petitioner is hereby cancelled with immediate effect under the provisions of the MMDR Act 1957 and the Amendment Act 2021. Now, this entire exercise, in my respectful submission, my lords, has been completely one, of course, most importantly, my lords, when the matter is sub judice before my lords, and when I have a prayer in the earlier writ petition, my lords, categorically regarding the validity of my mining lease. So that is a prayer. I'll show to my lords in my previous, the first writ petition, which I was pointing out, the order which I was pointing out to my lord. There's a specific prayer that there should be a writ of mandamus declaring the mining lease to be valid. And my lords have seen that the order which was passed for the revocation of the mining lease, the single judge notes the entire my lord's history. So therefore, this is actually, my lords, in my respectful submission, an extension of the first writ petition. And without notice to me, and in an affidavit, it is for the first time disclosed to me that there is a cancellation. The cancellation order is not communicated to me, and my lord, it is sent to another address. And after repeated reminders, I get the cancellation order, and I'm before my lords today. So there are two aspects to that, my lord. The first is the legal point that it was done, my lords, without following the principles of natural justice. So therefore, my lords, this needs to be, my lords, kept at the same order should be passed. And more importantly, my lords,
No, tell me, Mr. Counsel, the basis of this provisional mining lease, what are you doing?
no, nothing. This is only a condition, my lords. I will show the mining lease. The mining lease has conditions which says that you have to obtain the other statutory clearances. So today, there is nothing that I can do. Anyways, my lords, the matter relating to the
And when
mining
the
plan.
question arises of giving an interim order.
No, my lords, the earlier round also, without the mining plan, I cannot anyways mine. And otherwise also, without the statutory clearances also, I cannot do any mining operation. That is, well, that is no problem. We are not saying that we want to carry out mining operations. But my lords, so far as the cancellation is concerned, today what will happen, my lords, is if this particular proceedings are not stayed, then my previous writ petition will also become infructuous, because one follows the other. They are both, my lords, intrinsically linked together, because the grounds on which today the cancellation order is passed is exactly identical to what was done in the previous round for the revocation.
But
On the
Mr.
same ground.
Counsel, if I stay this proceed, that order,
Yes,
wouldn't that amount to prejudging the issue now?
in my
That
respectful
too,
submission,
without giving the other side an opportunity of putting on affidavit, what is the stand, and more particularly as to whether the exceptions to the principles of natural justice would apply.
my lords, in my respectful submission, I was not given any notice of this. If I was given notice of this, then my lords are absolutely right, my lords. I will take
Huh.
the point that,
Understood. Let us assume that you had not been given a notice.
yes,
But whether the exceptions to the principles of natural justice would apply here, taking into account that there was a mining lease, which were mining permits, which was required, which you did not have. Whether the statute mandates
yes,
that
I
you
agree with you.
required to have all
I agree
these
with you.
things.
Yes,
So they have passed an order, rightly or wrongly.
yes.
Let them put it,
I will give you a badge, my lords. My lords,
let
will
us
please see the
come to
statute.
learn. Mr.
Please see
Counsel,
the statute, my lords.
you put them to notice, ask them to file an affidavit.
My lords will please see the, my lords, what was fallen from my
Because
lords.
because at this stage, when there is a cancellation, the question of revoking does not revoking by way of a interim
No,
order
I am
does
not
not
asking for
arise.
revocation. I am only saying that please stay the operation of that order. Because
How?
my lords,
How do
the
I stay an
cancellation- the
operation of a
of the
cancellation
lease.
order
My lords, the cancellation of the
by
lease.
at a motion stage?
My lords, I am only saying that the order. by
You were
which
lucky
the-
enough to get an order of the earlier time to get a stay.
No, in that case also the same thing happened, my lords. My lords, I'll read the order to
Understood.
my lord.
That is why I'm saying you were lucky enough.
My lord, can I just show my lords the order
I've seen
and the provisions, my lords will please see, my lords. My lords have put a question to me, and my lords, I have a clean answer to that.
Hmm.
My lords will please see the provision itself.
Show me.
My lords will kindly come to what is the number? The statute compilation. Yes, yes. My lords will kindly turn to page 11 of the compilation.
7.
11, my lords. 1.
Yeah.
My lords will come to
Oh, thank you, Diana. Can you give a copy of the hearing? Yes. My lord. Sorry, my lord, I was next in court number 1. Now, my learned friend must have already argued the matter. Now, this is the second round.
Understood, Mr. Chaudhary, but the question is,
It's a
rightly or wrong,
statutory
no,
requirement.
let us understand, rightly or wrongly, an order has been passed cancelling. Don't you think that it would be more fair for this court to put the other side to notice
Yes.
and then ask them to get their stand and dispose of the matter at an early date?
Very well. Only thing is, my lord,
Because the question of staying now, how is it going to affect you? Except that the earlier petition may have only that earlier petition thing. But in view of that disorder, the earlier petition has also lost to some extent the force.
no, with all respect, my lord, if the order is not stayed, then it will be too late in the day, my lord, for us. Kindly see, my lord. Now,
where you
the very-
I would have, if you were running, you were not doing anything.
No, my lord, permissions and everything is the only thing is, my lord, that environment clearance is awaited.
That is the
only thing.
most
Yes.
pertinent aspect. Without that, you cannot. Without a mining permit, you cannot.
Yes, without the environment clearance, perhaps we cannot operate. We cannot operate the mine. But question is, my lord, our status, our right, subsisting right will be disturbed, my lord. Tomorrow, how do we claim? There is a right which I have come to enforce. What is my right, my lord? To operate the mining lease. Now that lease is sought to be truncated in a manner which is not envisaged by the statute. I'm entitled to a notice, my lord. That is not given. Kindly see the rules. If your lordship will kindly have section 4, my lord, page 4A3 at page 11 of the compilation. Page 11, 4A it starts, my lord. And if your lordship will kindly come to page 12 of the compilation, subsection 3. The statutory prescription, no order making a premature termination of a prospecting license or mining lease shall be made, except after giving holder of the license or a lease a reasonable opportunity of being heard. What is envisaged is the hearing, effective hearing. We are alleging violation of this statutory prescription.
But where is the lease?
Lord,
Where is the mining lease?
yes, it is there. 10102, my lord, of the petition. Page 102. The deed for granting of mining lease is made by and between the following. This indenture made on 29th day of January of 2021 between Governor of Arunachal Pradesh acting to the Secretary Department of so-and-so, which expression, etc., and Shri so-and-so. Background, the lessee had been Para B, accordingly, state government is now executing this deed for grant of lease to the lessee in consideration of the fee, royalty, covenants, and agreements hereinafter reserved and contained on the part of the lessee to be paid, observed, and performed. And at page 104, my lord, state government hereby grants the lease to the lessee over an area described in Schedule B for conducting mining operation for a period of 50 years, commencing from the date on which this duly executed mining lease is registered with respect to graphite. So, my lord, this lease is now sought to be cancelled without notice. In the earlier round of litigation, our dispute was with regard to, my lord, prospective license.
Now, have you gone ahead with your mining operation?
No, because we are awaiting the environment clearance.
Now, 2 years have passed by. How do you take care of a situation? Wouldn't that amount to automatic cancellation of this?
Actually, what had happened, my lord, in between, because of COVID, about almost 2 Almost 2 years gone there. Now thereafter it is everything is in the final stage, my lord.
You entered into the mining lease at the peak of the COVID.
Only thing is, my lord, we are
No,
selling the
Mr.
decision making
Chaudhary,
process.
Mr. Chaudhary, the best thing is let me put them on affidavit. Let them be provide. If the matter requires I'll take up the matter on an early disposal. But the question of stay would not be given now. There's a question of because, in my opinion, if I stay
Or
this,
at least lordship should make one observation in respect of this particular area over which you have been given.
there shall not
there will
be
not
any
be
other.
third party right.
Yes,
And
that
it
I
will
will.
not be put to auction.
That I will do.
Yes.
That I will.
Okay.
Yes,
They're not
now,
lost.
Mr. V.D. Goswami.
My lord, they have come after order of 2022 now, my lord. They say they are not aware, they are following up, my lord.
No, it's okay.
That- and
It's
also, my
okay.
lord, and
No,
also,
no,
my
no,
lord,
Mr.
application
Goswami,
of-
I understand everything.
Right.
Only thing I want to know, you have in all your letters emphasized that you have intimated him about the order of cancellation.
Right.
Where is any letter or even a whisper in the cancellation order that you put them to notice?
Is
That is the only line.
Letter speaks of it, my lord, at page
No, no.
251.
Huh?
At the letter at page 251, my lord. Addressed to
251.
the director of the Steno Cement.
Yeah, that is what I'm saying. That letter only says
But
that we send you the order of cancellation.
My lord.
I'm not on that.
My lord.
Well, you have passed an order of cancellation, very good. But where is when in the cancellation that you said that you have put them to notice or inform them that we are going to terminate?
That, my lord, instructions, my lord, I am appearing for the first time, my lord. That instruction I am.
my lord, actually,
I am
page
also looking
251.
at the matter
Page
for the last-
251, my lord, they communicated the order on 4th of June.
No, no,
Page
that I've
251.
seen it. No, in fact, in the cancellation order
no
also, there is not a single whisper that they have informed. What they say that in view of the amendment, this has happened.
That the right ceases, which is again.
So
wrong.
the question would be whether we have to understand that this is in violation to the principles of natural justice, but as well as the mandate of Section 4A. But the question is whether the Arunachal government could come with a plea of an exception to the principles of natural justice. That is the small limited sphere. So a very short affidavit. So we finish up the matter very soon. But for a matter to be pending for these type of matters should not be pending for long.
Yes, my lord, I agree with you.
Mr. Kane Chaudhary, the Learned Senior Counsel, along with Mr.
P.P. Sharma.
the Senior Counsel, assisted by so and so. Appearing on behalf of the petitioner, he appears on behalf of
Oh, respond number one, my lord.
an Advocate General. Arunachal Pradesh appears on behalf of the respondent. I want to make that person who have issued it, the secretary, a party.
Not a party.
He is the main person who is doing all these things to you.
My lord, we'll file an additional memo of parties. Actually, my lord, he is holding dual post. In any case, my lord, there's a requirement. We'll do that. File a memo of parties.
Heard Mr. So and so for a petition. Perusal of the petition reveals that the petitioners herein have assailed the order dated 14th of July 2022 issued by the Secretary, Geology and Mining, Government of Arunachal Pradesh, Itanagar, whereby the provisional mining lease issued to the petitioner in respect of graphite deposit over an area of 4.96 square kilometers in Taliha, Upper Subansiri district, Arunachal Pradesh, was cancelled. Mr. Ken Chaudhary, the learned senior counsel, submitted that taking into account that the Secretary, Geology and Mining, Government of Arunachal Pradesh, Itanagar, had issued the said impugned order, the said Secretary, Geology and Mining, Government of Arunachal Pradesh should be arrayed as the party to the instant proceedings. This court is also of the opinion that the Secretary, Geology and Mining, Government of Arunachal Pradesh is required to be impleaded in the instant petition, taking into account that his presence would be necessary for an effective adjudication of the writ petition. Accordingly, the Secretary, Geology and Mining, Government of Arunachal Pradesh, Itanagar, having his office at where?
Itanagar, madam. Huh? Secretary, my lord, Itanagar. This secretary.
Itanagar.
Huh?
RK Mission Compound, Itanagar.
Itanagar, Arunachal Pradesh, is arrayed as respondent number 1, capital A. The counsel appearing on behalf of the petitioners are directed to file a fresh memo of parties before the registry of this court during the course of the day, and on the basis thereof, the cause title would be on the basis thereof, the learned the registry shall make necessary changes in the cause title as well as also update the same in the CIS. Mr. B.D. Goswami, the learned additional advocate general, appears on behalf of the respondent number 1 and 1A and accepts notice. As regards the respondent number 2, on number 2, Ms. B. Sharma accepts notice. As regards the respondent number 3, the petitioner is directed to take steps by way of registered as well as usual during the course of the day. As the respondent numbers 1, 1A, and 2 are duly represented by their respective counsels, the extra copies of the writ petition be served upon them during the course of the day. The case of the petitioners herein is that the petitioners were granted a mining lease for graphite over an area of 4.96 square kilometers in Taliha, Upper Subansiri district, Arunachal Pradesh. By the letter of intent dated 21/8/2019 for 50 years. And in that regard, a mining lease was also entered into on 29th of January 2021.
Grant of mining lease, page 91. 29/1/21
Is the mining lease.
It's, yeah, grant of mining. Yes.
No, grant of, this is a mining lease.
Yes.
And grant of mining lease is by the letter of intent.
No, my lord, by page 90.
Kindly see page 102.
No, my lord, if your lordship will kindly come to page 90. In exercise of the power conferred by subsection 2 of section 5 of the so-and-so act, government of Arunachal hereby grants the mining lease for
So therefore I said, have granted the mining lease by a letter of intent dated so and so.
No,
This is
letter of
the-
intent was earlier, my lord.
So here in page 102,
79 is the letter of intent.
kindly see 102. Down the background.
My lord.
Page 102 background.
Once. Page 102.
Ah.
Yes, the lease has been granted letter of intent for my. No, initially it was letter of intent, my lord, followed by that grant of the mining lease.
Had entered into a mining lease on 29th of January 2021.
It preceded
On the same day, the respondent number 1A had also issued the grant of mining lease in favor of the petitioner. Where is the earlier order?
of this honorable court, my lord. It's at page
Two,
number
two, my lord. Triple two.
211.
No,
Sorry,
214.
214.
213.
7/120. And the operative portion is at, my lord, page number 220.
The court could have disposed of the repetition with so much writing of it. A challenge was made. The petitioners pursuant to the mining lease. So granted and entering into the mining lease. Applied for a mining plan. However, the mining plan of the petitioner was revoked by the Regional Controller of Mines, Indian Bureau of Mines, Bhubaneswar, and Guwahati Regional Office of the as well as by the Regional Controller of Mines was revoked by the Regional Controller of Mines, Indian Bureau of Mines, Bhubaneswar, by an order dated 7/1/2022. This revocation was put to challenge by the petitioner by filing a petition being WPC number 1104/2022. This court, by an elaborate order, issued notice dated 4/4/2022 and directed that till the returnable date, the operation of the revocation of the approval of the mining plan along with the progressive mine closure plan in respect of Taliha graphite deposit over an area of 4.96 4.96 hectares in Taliha Upper Subansiri, district of Arunachal Pradesh, by the regional controller of mines, issued by communication dated 7/1/2022 shall remain suspended. What happened thereafter?
Extended, sir.
It has been informed to this court that the said order has been extended from time to time. In the said proceedings, an affidavit was filed by the state of Arunachal Pradesh. An additional affidavit was filed by the state of Arunachal Pradesh, wherein, as per the petitioner, for the first time, it was disclosed that the mining lease, as well as the grant of the mining lease, have been cancelled by a communication dated, by the impugned communication dated 14/7/2022. It is, as the petitioner could come to learn about the same recently, on the basis of another communication dated 4/6/2024, the petitioner have assailed the mining lease, the impugned have assailed the cancellation of the provisional mining lease dated 14/7/2022 by way of the instant writ petition. Mr. K. N. Chaudhary, the learned counsel appearing on behalf of the petitioner, submitted that while issuing the impugned cancellation order, the principles of natural justice have been given a go by. Not only that, the learned senior counsel has also referred to, it's a section or a rule, section
My lord.
4A
For capital A,
of the
subsection
Mines
three.
and Mineral Development and Regulation Act 1957, which also categorically mandates that no order making a premature termination of a prospecting license or a mining lease shall be made except after giving the holder of the license or lease a reasonable opportunity of being heard. The learned senior counsel further submitted that even a perusal of the impugned order would show that there is not a single whisper that the petitioners herein were given any notice prior to issuance of the impugned order. Under such circumstances, the learned counsel submitted that this is a fit case where this court should exercise its rich jurisdiction under Article 226 of the Constitution. The learned counsel further submits that there is a apprehension of the petitioner that the said mining lease have been cancelled on account of certain vested interest, and under such circumstances, there is also a possibility that the said mining lease, a third-party rights may be created upon the said area wherein the petitioner was granted a mining lease. Full-stop. He therefore submitted that certain interim protections are required to be granted by this court at this stage. I've heard also Mr. B.D. Goswami, the learned advocate, additional advocate general, who submitted that the petitioners have assailed, were issued the order, impugned order on 14th of July 2022, and the due notice about the cancellation order have been given. However, it is after a lapse of 2 years, the petitioners have approached this court. In addition to that, the learned counsel submitted that the said mining lease have been cancelled in view of the provisions in view of non-fulfilling the prerequisite conditions of the mines and of the requisite conditions as prescribed under Section 5(2)(b) of the Mines and Minerals Development and Regulation Act 1957. he therefore submits that this is not a case where there any interference is called for. This court had put a specific query upon the learned counsel, additional advocate general, as to whether any notice, whether the mandate of section 4A(3) of the Mines and Minerals Development and Regulation Act 1957 have been duly adhered to, taking into account that it is a statute mandate of the provisions of the said act. Footstep. The learned counsel, therefore, additional advocate general submits that he would take instructions in that regard. Footstep. Under such, this court have also perused the impugned order of cancellation, wherein there is not any reference made to the effect that the petitioners herein have been given any notice. Under such circumstances, this court fixes this matter. You should notice, returnable on. When can you file your affidavit?
3 weeks time. Your lordship can fix a date.
On 21st? On 21st of August. We have it on 28. 28. You should notice making it returnable on here. Taking into account the above, this court fixes the matter on 28th of August 2024. The respondents are directed, the respondent number 1 and 1A are directed to file the affidavits on or before 21st of August 2024. The petitioner, if so advised, would be at liberty to file the reply by 27th of August 2024. This court, having taken note of the submissions of the learned senior counsel, is of the opinion that if any third-party rights are created over the mine in question, it would further complicate the issue. Under such circumstances, till the next date, the respondent number 1 and 1A are directed not to create any third-party rights interest in respect to the mine being respect to the mine pertaining to graphite deposit over an area of 4.96 square kilometers in Kaliha, Upper Subansiri district, Arunachal.
Instead of 20, it could be 29.
Okay, we can. 29th is a Thursday.
Much obliged.
I don't know, 38.
Any supplement? It does. Yes, Mr. Sakya.
Matter pertains to my lord recovery of the entire revenue amount from the petitioner, although he has
Separate cut, bifurcate the lands of the petitioner from the land belonged to his uncle Sonam from the parts of Iman, under Iman. What do you want?
my lord, the petitioner was forced to my lord pay the entire revenue of entire land belonging to a joint family. Though he has submitted petition before the circle officer,
For what?
his portion should be my lord.
Why you are not asking for partition? Before the circle officer and ask for a partition? Or don't pay?
If I not pay my lord, they should notice my demand notice my lord.
No,
Asking me to
pay,
pay.
then demand, then pay. Either you are to take yourself out by asking for a partition. Otherwise, if it is a joint patta,
There, my lord, on that
no. Family settlement cannot happen. You have to move an application under 99 Assam.
Yes,
Go there.
yes.
Nothing doing. Go there. Mr. P.J. Saikia, the learned counsel appearing on behalf of the petitioner, submits that he would approach the revenue authorities for partition of the land belonging to the petitioner. And as such, he would not like to press the instant petition. Accordingly, the instant petition stands closed on withdrawal.
problem.
99 for partition की वो कुछ नहीं पूरी 99 of the Assam Land and Revenue Regulation. Yes, what is this?
This your lordship, the petitioners have been.
I could have disposed of that matter on that day itself. Yes.
Possessing land more than 30 years by constructing dwelling.
Setting aside and quashing the impugned notice and further issue a direction directing Ria to pay adequate compensation to Ria for acquisition of his occupied land. You have already been thrown out.
Some portion is thrown out. You see that notice has been served in immediate. Last year, they have informed to remove, but after that, they have approached the responsible authorities for some compensation as per right to fair and your lordship compensation transfer land acquisition.
You will be getting, where is your land? Where? Which house? Annexure 2. Makum. You are saying about this house,
Shop also, your lordship.
the shop. And where is your house?
That side and one side is shop.
And how much is left of the house? There is the photo of how much is left.
Earlier, your lordship, they have.
Understood. That is earlier, but this is of 2023. What is remaining today?
They have not paid compensation.
Why will they pay?
So they have the right to pay compensation area, your lordship, section 3, your lordship, and the values. 3, section 3C2. I'm reading it. A family which does not own land but a member of members of family.
So you say that you are a person interested, and as such, your case should have been considered.
Because my family is livelihood on this business or.
You may be entitled to the Zirat. Yes, Mr. Talukdar,
But your lordship.
he is entitled to the Zirat.
Lordship is constructed, Lordship, paragraph 8, Lordship. Paragraph 10 of the requisition. Sorry, page 10 of the requisition.
Para?
Paragraph 8, Lordship.
That
It's
his
clearly
family has
stated
been possessing a government land under drug number so and so by constructing dwelling houses for more than 30 years, which is long construction prior to the construction of the NH. It is no other land except the above mentioned occupier, and his grocery shop is all. Then
Lordship, since the matter land is under government lordship, so he's an cursor lordship, and accordingly, Lordship, in terms of National Highways Act, Lordship, we issued that notice, Lordship. That is, Lordship will find in page, Lordship, Annexure 6, page 29, my lord.
Excess 6, please. Yes.
It is unauthorized occupation, my lord.
So he submitted a representation. And what did you do?
They have nothing to say.
Huh?
They have nothing to say.
What did
Earlier,
you
your
do?
lordship, once representation, kindly on page 28. Page Annexure 5. Earlier, also last year also I have approached when it was. Then page 28 then. This is directed to sir.
And
Action has been taken place then.
no, everything is understood. He may not have a right over the land. He would not get any compensation for the land. But what about the Zirat? How do you take care of a right of a person who is in occupation? Have you seen the definition of person interested? Whether the person interested here will have the same meaning in terms with section of the National Highways account.
Yes, sir.
Lordship, his prayer, Lordship, to pay adequate compensation to the petitioner for acquisition of his occupied land, Lordship. His prayer, Lordship. There is no ziraat exists in that land, Lordship.
For the land, he is not going to get.
Lordship. And for getting compensation, his name is to be included in the notification, Lordship, gazette notification, Lordship. His name, his land is to be included in the gazette notification, Lordship, for getting land compensation, Lordship. But since he is an unauthorized occupant, Lordship, he has not given any prior permission from the government at the time of construction, Lordship. And that is not stated in the petition also, Lordship.
What will happen to persons who are, see, can you incorporate the provisions of the right to fair compensation? You cannot. Only for the purpose of compensation you can. Termination of compensation, nothing more than that. But can you bring in the concept of person interested in the Land Acquisition Act? Yeah. Because what National Highway is doing, sometimes they are paying. In one case, they have paid for the purpose of taking over the school, but they are not paying anything for the purpose of paying for the land. They appeared there.
Yes, Lordship. That,
Then how are you doing it? How is it possible? In that case also, your specific case out there is, look here, he is in government land.
In
He
that
is not
case, Lordship,
entitled
Deputy
to.
Commissioner-
However,
I-
for the
Lordship.
house building, we have given them 10,33,000.
Lordship, as far as my knowledge, in that case, Lordship, Deputy Commissioner has allotted the land to school, Lordship. In that case,
No.
Lordship.
That is what I held. There was a proposal for allotment. There was no allotment.
But here in this case, Lordship, he is prayed for land, Lordship, occupied land, Lordship.
So you will modify it.
For compensation for what?
They
He
didn't
wants
file-
compensation. Don't go by the words, go by the flavor of the petition.
I have said, submitting in terms of his prayer, my lord.
He will ask, Mr. Islam ask many things. You have to read between the words, between the lines, everything. When it is a case of 300A, you read everything. Hello, let us issue notice in this case. Issue notice. No, why Mr. Islam, I was going into deep at this stage is, you see, delaying the disposal of this petition is not going to be in your interest. We can pass an order for you to get the compensation of the house.
That's
The best way out.
I'm only for house here, business. House for yours, for Zirat yours, because that there is a letter also, page 28. It is additional district commissioner sent to circle officer after my representation.
Hello, we do one thing, we dispose it of. And giving you an opportunity for submitting a representation before ER in respect to the house standing and the loss caused on account of the house. Not as regards the.
Lordship,
And they will, the deputy commissioner, I will ask them to consider, the competent authority to Kala, the competent authority to consider.
Lordship, I'm relying on order, Lordship, but that is WPC number 1050/2016, my lord. In that case, Lordship, this honorable court held that since the government, Lordship, as an occupation, the petitioner may have right to receive Zirat compensation for trees and others, but since the land is government land, the claim to compensation may not be completely tenable, Lordship. This court has held, Lordship.
Yes.
So
Then
since his Lordship,
after my order which I have passed, go to the division bench. So that
Lordship,
this court did not listen to
Lordship,
any.
let the notice go, Lordship will file response, then
Nothing
Lordship
doing.
will pass order.
I am not passing an order against you. I am passing an order against in his favor, not affecting anybody. He has no objection. But Mr. S. Islam, the learned counsel appearing on behalf of the petitioner. Mr. R.K. Talukder appears on behalf of the respondent numbers 2 and 3.
3 and 4, my lord.
2, 3, 4.
Lordship,
I'm for 2, Your Lordship.
2
I'm
and 4.
I'm for 3 and 4, my lord.
Appears for respondent number 3 and 4.
I'm
Mr.
for response number 2, Your Lordship.
And so appears for respondent number 2. And Mr. A. Bhachaji appears for respondent number 1. And Mr. N. Goswami appears for the respondent number 5, 6, and 7. The petitioner herein have filed the instant writ petition claiming compensation in respect to the land wherein he had set up a shop as well as a house, as well as his residence. The said land is covered by Dag number 283 of village Makum Junction, Gaon under Dumduma Revenue Circle. Being aggrieved by the action on the part of the respondent authorities in not granting compensation to the petitioner on account of the land being a government land, the petitioner has approached this court by filing the instant writ petition. This court had put a specific query upon the learned counsel appearing on behalf of the petitioner as to whether the petitioner have sought compensation in respect to the land or the house standing thereon. The learned counsel appearing on behalf of the petitioner submits that as per his representation, as well as also the instant petition, the petitioner have sought for compensation for the land. This court, taking into account that admittedly the land in question was a government land, and there has been no right created in favor of the petitioner would not be entitled to any compensation in respect to the land in question. However, if the petitioner has any house standing thereon and any loss is caused, in the opinion of this court, the petitioner would come within the ambit of a person interested to claim compensation in respect to the house standing thereon. The learned counsel for the petitioner therefore submits that he may be given the liberty to submit a representation before the competent authority, that is the respondent number 5 in that regard. This court, taking into account the said, is of the opinion that the petitioner be required to be given an opportunity to submit a representation before the respondent number 6. I think it will be 6, na? He's Kalana. He's the competent authority.
Additional, yes, Lordship.
Huh?
Yes.
To the respondent number 6. And the respondent number 6 shall duly take into consideration that on the basis of the materials so placed, and take into consideration the said representation if any claim is made in respect to the house standing over the said land. With the above, the instant petition stands disposed. I think this is the only way.
On the paper already submitted before the ADC.
For land, you are asking.
I was also mentioned.
House mentioned.
Page 26.
You specifically submit along with a copy of the instant order. The respondent number 6, 5 and 6 are directed to duly. Respondent number 6 is directed to consider such representation so submitted.
July.
along with the certified copy.
And pass appropriate order, my lord.
Huh?
And pass appropriate order.
You will do. I'm not asking that because that will be again giving another thing. So you will consider. Yes, what is this? Yesterday matter.
Yesterday's matter, Lordship, this is 2019-20. Lordship, in this case, we are challenging the SOPOS notice. Lordship, may kindly see section 73(2). This notice is time barred, Lordship. As per section 73(2). 73(2) says that whenever, if you want to pass an order under section 73(10), then in that case, Lordship, that SOPOS notice has to be given 3 months prior to that. This notice is on Lordship of May. And Lordship, the last date of, as per Lordship notification, the recommendation of the council, it should be June. 30th of June 2024 was the last date of passing the Lordship order of adjudication. My notice is Lordship dated 8/5/2024. It should have been given. Lordship, page number 81 is my notice. DRC 1 is the SOPOS notice, Lordship.
Then order passed when?
Order is not passed, Lordship. This is the notice which is in issue, and I have challenged this notice.
This is 1920.
And 1920, Lordship, the order ought to have been passed by 30th of June 2024. SOPOS notice has to be issued under section provisions of section 73(2), 3 months before the last date of passing the order. This is the time limit which has been given under the Act, under section 73(2).
At least.
At least 3 months. Or maybe before that.
How does it matter?
Lordship, if Lordship, this time limit is not adhered to, and 3 months is not given before the last date of passing of the order, Lordship, it becomes time barred.
No, it's okay. But if they pass an order within that 36,
36 is already over, Lordship. We are in Lordship August.
now have they passed the order? That?
Lordship, they have not.
No, the issuance of notice. Now there is no mention as to when the notice has to be passed. See, kindly come 10, 9, 9. 10. The proper officer shall issue the order under 9 within 3 years from the due date for furnishing of the annual return for financial year to which tax not paid or short levied is so and so month.
That is also not compliant with Lordship. They should have passed an order by 30th of June. So Lordship, this notice goes. Even if it is seen that
This is state government.
the state government as well as the state, the notice is by state government, Lordship, and the notification is of the central government. Lordship, in similar cases, Lordship, this honorable court has stated the SOPOS notice, said that it has said that till further order, any final order will not be passed. This is the
But if the final order has been passed,
Lordship, till now no final order.
they have not informed you. They must be keeping it in their pockets.
They have not issued me the Lordship. The hearing has not taken place. They will issue in the last week, Lordship.
What does it say? Does it say about a hearing?
No, Lordship.
We'll do it mechanically, which they have the habit of doing it.
I'm
Yes.
central.
Huh?
State GST will be. No, is there.
It is not there. Or Mr. Miss N. Haveli, the learned counsel, appearing on behalf of the petitioner. The NJ Gogoi,
Can go.
BN Gogoi. The B.N. Gogoi appears on behalf of the respondent number 1 and 2 and appears on behalf of the GST, state GST on call. It has been informed by the learned counsel appearing on behalf of the petitioner that there is a standing counsel available for the state GST.
They've come.
Liberty is given to the counsel for the petitioner to serve, to furnish, issue notice, take steps upon the state's notice, making it returnable on. When did I fix the earlier matter?
21st of August. 21st of August.
21st of August 2024. The petitioner herein have assailed the instant writ petition. Have assailed in the instant writ petition the notification number 9/2023 dated 31/3/2023. Why you are challenging this?
Lordship did not challenge. 56 is the only.
Challenge the notification dated 56/2023 dated 28/12/2023. Issued by the respondent number 2, thereby extending the limitation under the provisions of Section 73(10) of the Central Goods and Service Tax Act 2017, as well as the notice under DRC 1 dated 8/5/2024, issued by the respondent number 4 under Section 73 of the GST Act 2017 for the period 2019-20, along with attachment to DRC 1 dated 8/5/2024. So this notice is under 73 of the CGST,
Yes.
nothing to do with the state.
Issued by the state authority.
Maybe, but this is under the GST Act, Central
Yes.
GST. The case of the petitioner herein is that the notification which was issued in notification number 56/2023 dated 28/12/2023 is ultra-virus the provisions of Section 168A of the CGST Act 2017, inasmuch as the said notification has been issued without taking the recommendation from the GST Council, which is otherwise a mandatory condition. In addition to that, the learned counsel appearing on behalf of the petitioner submitted that the same notification also submitted that the powers under Section 168A can only be exercised in the circumstance there is a force majeure. Referring to the minutes of the 49th meeting of the GST Council, the learned counsel submitted that the reason why they are the respondent authorities have sought for extension is very well spelled out, and it will be seen that the reason for which extension is that they do not have the adequate staff to complete the audit, assessment, etc. He submits that not having the staff, the officers and staff to complete an assessment or an audit under no circumstance can be said to be a force majeure. The learned counsel for the petitioner further drawing the attention of this court to Section 73(2) of the CGST Act 2017, further submitted that in the instant case, the notice was issued on 8/5/2024. In terms of the mandate of the said section, the said notice has to be issued 3 months prior to the passing of an order under Section 73(9). Under such circumstances, referring back to the notification, again referring back to her submission that The notification number 56/2023 is ultra-virus. She submitted that the notice as well as the notice so issued on 8/5/2024 as well as the order to be passed would all be ultra-virus. The order would be contrary to the Act of CGST Act of 2017. This court have been given an anxious consideration to the matter, is of the opinion that the matter as to whether there was a force measure and what were the circumstances under which the Section 168A, the provisions of Section 168A was invoked, would require a determination, and the same can be done on the basis of an affidavit to be filed by the respondent authorities. Be that as it may, perusal of the materials on record prima facie shows that that there was no recommendation made by the GST Council, which is GST Council, before issuance of the notification dated 56/2023, dated 28/12/2023. Under such circumstances, this court, it is also the opinion of this court that if the notification number 56/2023 cannot stand the scrutiny of law, all subsequent action taken on the basis thereof also cannot be sustainable. Under such circumstances, this court, till the next date, directs the respondent authorities not to take any course of action against the petitioner pursuant to the notice dated, as in respect to the notice dated 8/5/2024.
Okay, but this name was not reflected in the call, that's why.
Oh, you are appearing?
Yes.
Two and three and four he appears. 1 and 2, Mr. A. Huh? Issue notice making it returnable on swell. File your affidavit.
Yes. All name may be reflected in the cause.
The registry shall reflect the name of Mr. B. Chaudhary, GA,
FGST.
SC, Finance and Taxation.
The land in question has already been corrected in the name of the respondents. My lord. The land in question, my lord, has already been corrected in the name of the respondents.
Can I know?
Terms of.
Heard Mr. A. Hussain, the learned counsel, appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent numbers
2, 3 and 4.
I'm the Revenue Department.
4. 2, 3, and 4. Mr. A. Bhattacharya, you have N. Godlo appears on behalf. The Khandakar appears on behalf 5 to 7. The instant petition has been filed by the petitioner challenging the order dated 19/12/2015 passed in Miss Appeal number 14/15 by the settlement officer, Hubri. In addition to that, the petitioner have also assailed the communication dated 10/10/2019 issued by the Assistant Settlement Officer Bilasipara and have sought for a direction upon the respondent authorities, more particularly the respondent number 3 and 4, to make correction of the land records in the land records pertaining to new dark number 2822 and 2825 under patta number 1612 at village Nayal YERALGA, part Roman 3, by adding land measuring 4 bighas 2 katha 2 lechas in the name of the petitioners as per the deed of sale bearing deed number 1945/169 and 139/147. This court have duly perused the materials on record. It is seen that pursuant to there are disputes between the petitioner and the private respondents over the plot of land measuring 4 bigha 2 katha 2 lechas covered by dag number 2822 and 2825 under patta number 1612 at village so and so, part Roman 3 of what? Roman 3. Where is the land? Under Vilasipara Revenue Circle. It is further seen that on 19/12/2015, the settlement officer had passed the order whereby a direction was issued to the ASO to correct the area of the land of new dark number 2825 comprising of old records from 2 bigha 0 katha 8 lechas to 4 bighas 4 katha 0 lecha. This order, which was passed on 19/12/2015, having not been complied with by the concerned authorities, the private respondents have approached this court by filing a writ petition being WPC number 3115/2017. And this court, by an order dated 10/6/2019, directed the settlement officer to duly comply. Directed the respondent, the assistant settlement officer, to make correction in terms with the order of the settlement officer dated 23/12/2015. Isn't that? Dated 19/12/2015. It is in pursuance to that the corrections were made and the notice impugned letter dated 10th of October 2019 was issued. This court, upon hearing the learned counsels for the parties, is of the opinion that any order, the order which the petitioners have sought for, if is required to be passed, it can be having heard the learned counsel is of the opinion that the order which the petitioners have sought for by way of the instant writ petition would be sitting on appeal against the order passed by the coordinate bench dated 10/6/2019 in WPC number 3115/2017. Accordingly, be that as it may, it has been also brought to the attention of this court that the private respondents have filed a suit being title suit number
101/2021. Earlier it was filed
101/2021, which is presently pending
before
the court of
Munsif cum CMFC Bileshipara.
wherein the issue of right title and interest in respect to the land in question is sub judice. Taking into account that it is a well-settled principle of law that a direction and a decree so passed by the civil court in respect to a right, title, and interest over a land would be binding on the revenue courts. This court is of the opinion that the order which have been passed on 19/12/2015 by the settlement officer, which is a subject matter of challenge before this court, would be subject to the outcome of the said suit. In addition to that, the petitioner herein will always be at liberty to file a suit if so advised. That is the only way out.
By order dated, my lord, the settlement officer, my lord, directed to correct the doc number 2825, my lord. But my lord, communication dated 10th October 2018, my lord, the assistant settlement officer, my lord, corrected the land, my lord, by deleting our doc number, my lord. 822. That doc number has completely been deleted, my lord.
No, that is even, my lord, my friend was saying it annex in the petition.
Yes, my lord, that is annex of 13.
As civil suit, claiming right, title, and interest against them. And by deleting, what did he do?
Our doc has completely been, my lord, deleted, my lord, and merged with the their doc number, the 2825, my lord. Total doc number has been deleted and merged with the land.
So part of the land given in his name, you cannot question.
But my lord, the doc number, our land is situated, my lord, 2822. That doc number has completely been deleted, my lord. As per this communication is deleted.
This court further observes that if the petitioner is aggrieved by the deletion of the DAG, which the learned counsel has submitted, the petitioner would also be at liberty to file an appeal before the learned Assam Board of Revenue within 30 days from.
Lord, an application has been filed before the settlement officer, my lord. Settlement officer, yes, sir.
Against an appeal lies before the Board of Revenue or not? Then go there.
Yes.
I'm on.
Right, sure.
Plus,
Item 9.
Yes, withdraw.
We have spoken to the.
You don't have a case. You have no land. Neither you have applied for. So, no case.
But Lordship, what in this petition, Lordship goes this 24 my FIR. Lordship, what has happened? One fine morning, two bulldozers have come and demolished the house and causing loss to my property without any notice whatsoever. Lordship, I seek in this. I also seek for compensation, Lordship, because they have also not registered my FIR. The police officials were there, the circles officer was there, the plot model was there, the local MLA was there. In the affidavit, Lordship, they say it was all done by an application to the DC by the local MLA. Now, Lordship,
Show me any semblance of right in 296. Any semblance of right in 296. Even as a Dokholkar or something that you were there. They say 296 is a roadside land. If it is a roadside land, you have no business. Show me that it is not a roadside land.
that is true, but what I am on is that
they could have given me, there is even no order to evict me, even in under the land policy, even for an encroacher, there has to be a scheme, Lordship. So for encroachers also, Lordship.
No scheme for encroachers. No scheme for encroachers. Encroachers are to be thrown out. I would have understood. Roadside land, you have to be thrown out.
Lordship, I
You show me any semblance of any right over that roadside land. That this is not, 296 was not a roadside land. Show me. Show me. That is the question. They categorically say that 297 we have not evicted. 296 we have. Your right, which had flown from anybody else, that person concerned who have applied, is also in respect of 297. That person concerned have applied before the authorities 297. They categorically say that 296 is a roadside land and as such we have done it. Where is yours any semblance of right over the land?
Lordship, first, they have for the boundaries also, they have not demarcated or that this is definitely 296 or so they have straight away come in the morning and demolish my house. Lordship, if they have given any order that this is 296, you please vacate or something, Lordship, I could have made my grievance clear.
They were, at that point of time, they were under an assumption that there was no necessity of issuance of a notice. It is only on 23rd of June, we have made it clear. Prior to that, everybody was under an assumption that 18.2 does not require any notice.
Yes, Lordship, and in the judgment also, para 63 for a roadside reserve also, somebody who, that is true, Lordship, somebody who has a bona fide claim can, Lordship. And
but if it is a roadside, you cannot. And it is very limited. You may so only to the effect that there was, that is not a roadside land. We don't have that, how do I help you?
Lordship, I am only on the arbitrary act of the public authorities. Lordship, one fine morning they came and they demolished the house. They do not register my FIR. I go to SP. SP doesn't register my FIR. I go to the DC. DC says there is no order.
Then go for 156.3. He does not done it, do under 156.3. Why didn't you go there? Is not to be done at the drop of the hat. They categorically say that 297 we have not touched. We have only done 296.
The records will speak for itself.
Why should I ask for records here, where you have not filed a reply also that it is 296? 297 they have done it.
Actually, only on that point, Lordship, may I just again, I'll file a short only on that point. Lordship.
What? You cannot file a affidavit just making an assumption. It has to be on the basis that 296 is not a roadside land. That is why I gave you the opportunity. Tell me that 296 is not a roadside land. Give an affidavit subject to 340 proceedings. Give an affidavit that 296 is not a roadside land.
If they say it, Lordship, 296 may be a roadside land.
Then
but
no business.
Whether I am occupying that 296 or not, that is the question, Lordship.
You were occupying 296, that is their question. That is specifically their allegation. We have, they say that 297, we have not touched it. Only 296. Tomorrow, roadside land, all these things, you keep on building houses. Why will they keep paying you compensation? You have no right on that. And maybe wasteland, you have a right of claim seeking salary. You even did not ask for settlement in 296.
Yes, sir.
Then you sought for settlement, not you, whoever it is, sought for in 297. Now tell me cost
I have to withdraw that.
better.
With liberty to that concerned person too.
The learned counsel, Mr. B.P. Bora, the learned counsel appearing on behalf of the petitioner, submits that in view of the stand taken by the respondents in the affidavit, the petitioner would not like to proceed with the instant petition. He, however, submits that he may be given a liberty to submit a representation before the concerned district commissioner, alleging if the land of the petitioner, if the building of the petitioner, which was demolished, was standing on dark number 297. And thereupon claimed compensation. This court is of the opinion that if the petitioner files that application, the petitioner is at liberty to file such application as submitted by the learned counsel.
And the concerned person, Sasi Bhushan Lordship.
Who?
The concerned person who has filed a settlement, whether he can reapproach the court, that the parent person, Sasi Bhushan, who is there from 1940.
Very good, very good. Now I start by issuing some orders on behalf of a person who does not even want to come.
Then
Deeply.
Yes, did he deposit?
Lordship, as per my information, there has been no deposit.
Yes, you were supposed to produce a document that you have deposited 25 lakhs. Give him a copy also. Mr. J. Roy, the learned senior counsel appearing on behalf of the petitioner today in pursuance to the order dated 22/7/2024, have placed an e-challan wherein it is seen that 25 lakhs of an amount of rupees 25 lakhs was deposited pursuant to the order dated 10/3/2024 on 15/3/2024, 23. 10/3/2023 on 15/3/2023. Dated bill litigation, 10/3/2000, wherein an amount of rupees 25 lakhs was deposited in pursuant to the order dated 10/3/2023. Now tell me, what affidavit have you filed?
Okay, I'll verify this and file an affidavit, Lordship.
You have not filed affidavit,
Not yet, Lordship.
not necessary.
We'll file now. Pursuant to this, we'll record this.
Mr. I. Bottago submits that he would duly verify the said aspect of the matter in as much as a copy of the challan has been also furnished to him. This court also takes note of that the petition has been pending since 2023 and no affidavit has been filed. Accordingly, this court fixes the matter on 9th of September 2024. The Excise Department is directed to file is given the final opportunity to file their affidavit, if so advised. On or before the next. The interim order passed earlier shall continue till the next.
Your losses. That's a case for my lord, protection, my lord, elopement, case of elopement, my lord, they are loving each other for since 2016, my lord. They got married without changing their date.
Yes, what is your case?
Yes, my lord, after coming out on 22, on 31, 2022, my lord, for a new year, they came out, my lord.
Who?
Both the girls and the boy. They went to different places. Actually, both the families are otherwise very liberal and are very mutual, with good connections and relations. But no case was filed also. But thereafter, after 1 month, a fabricated case was filed under some pressures from fundamental types of mandate and some local.
Huh?
Local petitions pressure. Father filed a case thereafter after 1 month.
Father of the two girls.
Father of the girl filed a case in CJM court. A fabricated story. Against which they also filed a quasi petition. It is also first day of the yesterday, my lord, in Honorable Court, which is not yet been uploaded. The false case was filed, my lord, but some of people in both the side are angry that if just trying to sort them out to teach a lesson to them, to kill them, like all these things. The girl, the boy sent several letters to the DGP Assam, SP Karimganj. My lord, kindly have a look. Hello, kindly turn to page.
Mr. Counsel, I'm not understanding. Hedo, tell what you are saying. Be a bit clear. Who are the two petitioners?
Inarani Das and Masumuddin.
Who are they?
They are now living as husband and wife.
Huh?
They are now living as husband and wife since.
Inarani Das and Masumuddin Uddin.
Yes.
Okay, then?
They left their house on 31/12/2022.
Okay, so they were major.
Major.
Then?
They are major, their birth certificate, all this I have annexed.
Then?
Then, though no cases filed by either side, but some local people of the villages, they tried to make out a case and to even try something. They tried, but the father did not agree. Thereafter, my lord, the people of some fundamentalist type minded people are trying to make it, even try to make it a case and trying to, asking them, then searching them to find them out and to kill them and to.
Who filed the FIR?
FIR later, like 1 month later. Father of the.
A case against the petitioner alleging kidnapping and other offences, and the father of the petitioner has.
Yes, after 1
in
month.
the meantime instituted a case against the petitioner. Number 2 alleging here. Now what happened?
Now, my lord, as they were searching to punish them, my lord, they were residing other places outside the state. And they filed, my lord, the petitions to DGP and SP, my lord, through emails, giving details, and then with hard copies also. They kindly give us protection. Our families are not disturbing, but others are disturbing us, and they may face serious situation for us if we go to our birthplace. So DGP responded, my lord, that and asked the SP to give protection. Sorry, to communicate with us and to give protection whatever necessary. But SP did not respond, my lord. Kindly turn to this, my lord, the emails and replies.
Then what happened?
Then, my lord, having no response, my lord, I have applied before the Honorable Court for this for protection. So the Honorable Court give us some protection on the interim, my lord, on that question, my lord. Only this may be direction may be given to the authorities, my lord, to give us protection so that we can go to our house. Only this one.
Here the order is not protection. Here is the order is not to take coercive action.
Yes. So
Coercive action is not protection. This is a case where somebody is taking an action against you and not to take.
My lord, because my lord, there is no case my lord, at all till now. And this fabricated case also, my lord, is quashed, my lord, by Honorable Court on the started, my lord.
No, you are fearing from whom?
From the villagers of.
So why are you filing a writ?
For granting protection to us, because police is not granting to us, not taking response, my lord. Yes, we have sent to.
So your case is that you need a protection from the villagers, which the police is not giving.
Not giving.
And you got an order out here that the police should not take any course of action against you.
My lord.
What is this?
My lord, but police is also, my lord, police is also sometime went to my house, went to our house. Where are they?
What has happened? You must have challenged this the FIR.
Yes, my lord, there is quashed.
FIR has been quashed.
Yes.
Where is that order?
My lord, this is not still uploaded. The day before yesterday is ordered on open court, but it not being perhaps signed and uploaded.
What was the petition number?
My lord, the Impleading 170 of 2023.
Mr.
Take it, Taluk.
A.K. Talukdar, the learned counsel appearing on behalf of the petitioner, submits that the Badarpur Police Station case number 32/2023, which was filed against the petitioner number 2, was challenged in criminal petition number
170 of 2023.
170/2023 before this court. He submits that the said proceedings with said Badarpur Police Station case number 32/2023 have been quashed by this court. However, he submits that some more time may be given to him for production of the certified copy. To list the matter again on 14th of August. But the order which you have got has no meaning now. Not to take coercive action. Who will take coercive action? So as of now, nothing remains. Badarpur Police Station.
Yes, case is done.
So now what is the effect?
But yes, your lordship is very much correct. My lord, we have
You
got the
need
order.
a order by which there's a direction given to the SP to give protection to you. Isn't that? Not to take a coercive action, it can only be passed against the respondent authority. Yeah.
Right.
Yes, what has happened?
The order challenged before the Supreme Court has been stayed.
Stayed.
Has not been passed. I got it. Order has not yet been signed.
Yes, Mr. Gupta.
Has been issued, my lord, we'll wait for the, my lord, the outcome of the SLP.
Miss B. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that that in SLP bearing diary number 24269/2024, the order passed by the division bench of this court have been stayed by an order dated 30/7/2024. She submits that the certified copy is yet to be received and accordingly seeks for some more time. List the matter again on (27/9/2024).
Interim to continue.
Interim order passed earlier.
matter relates to legal shifting of an Anganwadi center, my lord.
Affidavit filed by the government. What is their stand?
The earlier, it was shifted because of the erosion of the footprint. Earlier place is not suitable, so. The paragraph 4 and 5.
So you do one thing. You have lands out there. You build an Anganwadi center. They will function. It has been eroded off, the building. Where, how can they remain there?
Please come to page number 73 of my reply to your affidavit.
Huh?
I have filed a reply, my lord.
Yeah, what do you say?
Because, my lord, I have annexed some certificates issued by some authorities, my lord. They confirm and corroborate that the village was not eroded, my lord. And this is my case, our case, my lord. Page number 73 is the statement I have made, my lord, paragraph 7. And, my lord, I have annexed some certificates. Your lordship will find from page number 78 onwards, my lord.
Now, are these petitioners?
My lord.
How many? 16 or 17?
Petitioners are 49.
Out of them, many stay out. You are getting, somebody are getting away from other AWC survey.
Because, my lord, since 2019, the Anganwadi center is not functioning in that particular place.
Where?
At Burakat, I mean, in the original place where it was earlier established.
Burakata Pump.
So after this, my lord, when the center was not running there, definitely, my lord, the children who were there, my lord, and still are there, they have to go to some other centers, my lord. This is why their name has been registered in some other Anganwadi centers, my lord.
How far is it?
Is in nearby, my lord.
Then?
Because on the same, in the same village, my lord, they are saying that the village has been eroded, my lord. But
Not village. That building has been eroded. Not village. That is why I asked you.
Yes.
They categorically say
Lord.
that the deponent visited the place of Burakata Pump AWC and found that the AWC building completely eroded.
For that, my lord, if the building is eroded, my lord, meaning thereby, my lord, the center, it is not, the center is not no more necessary. The center is necessary. If it is eroded at some place, my lord, there are some other places they can run there, my lord. But what have they have
That
done?
is why I am saying,
Here, lord.
give your land.
Yes.
They will have a building. Isn't it?
Yeah.
Mr. Talukdar,
That's a good. We'll be happy.
you give an undertaking that you are going to give a land of yours, they will have the center there.
Lord, I can do that.
The learned counsel appearing on behalf of the petitioners submits that they would offer land to the state government for setting up an Anganwadi center. To list the matter again on 2nd of December 2024. The petitioners are given the liberty to offer any plot of land belonging to them to the government for setting up of an Anganwadi center nearby. Stop. The matter shall be taken into up for consideration on the next stage as to what happened, transpired, and the matter On the next date, Mr. B.J. Talukdar shall obtain instruction as to whether the petitioners have offered any land for the Anganwadi Center and what area.
Yes. That the villages petitioners are residing, my lord. All the lands are government land. So they have got no.
No, you give me your land. Your land, any of yours. Then only things will happen. They say that it has been eroded. They have put it from there to, how much is the distance from there to there?
No, my lord. the
How
present-
much is the distance, Mr. Counsel, from that to that?
Now the center is
No, how much is the distance from
more than
this
20
place?
kilometers, my lord.
Huh?
More than 20 kilometers away, my lord. Because the center is being run at the own house of the respondent number 6, who is the worker, my lord. Because she was earlier residing at Puragata Palm, my lord. Subsequently, she purchased a plot of land at Udmuri village, my lord, that is under Soigao LAC, my lord. So she has set up her residence there, and now she is running the center at her own residence. That is as many more than 20 kilometers away, my lord. This is our case that she has misguided the official respondents also, as well as the local villagers, my lord. Center is necessary there, my lord. But that and this, if your lordship is pleased to produce the certificate issued by the Gaon Pradhan as well as the Panchayat president and the headmaster, who is running a school in the same village, my lord. They have said the village has not eroded, my lord. But the respondent number 6, who is the worker, my lord, she has said that the village has been eroded. And based on her version, my lord, the official respondents are submitting their report that the building has been eroded or the village has been.
Building is still there,
It is still there, my lord.
not eroded.
The house was not completely constructed, my lord. Half of the construction was done, my lord. And thereafter, my lord, erosion was in fact there in some part of the village, my lord, in the same village. But the entire village has not been washed away. And the post
No,
was
building has not been washed away. I'm not saying whether the building has been eroded on account of erosion.
no, my lord. The place is still there.
लगे रखो. The learned counsel appearing on the learned Mr. B.J. Talukdar, the learned counsel appearing on behalf of the respondents is directed to apprise this court on the next date as to the distance between the earlier set up Anganwadi Center with the presently set up Anganwadi Center. And further, list the matter again on 21st of August. Get an instruction how much is the distance, you think?
Obliged.
15 and 15.
Your lordship. The case of a catering contractor again.
Same, na?
Same.
Yeah, the metro order this. Hey, sir.
Interim shall continue. Interim shall continue. Macho.
Yes, what is this?
Lord, this petition was filed, my lord, by direction to retake physical possession, my lord, of a secured asset, property. My lord. Physical possession was taken, my lord, under the guidance of the executive magistrate under orders in the section 14 of the SARFAESI Act. Subsequently, my lord, after 1 month, dispossessing and throwing out the security guards employed by the bank, the private respondents who are the borrowers, they have retaken the forceful possession. So the bank has filed an FIR also, but there is no remedy. Therefore, my lord, we seek a direction that the magistrate should be appointed again to retake the physical possession.
How? Why should we direct in that?
Because, my lord, the fact is that my lord, the forceful dispossession.
No, go there. Go there before the magistrate. Do whatever you like. Why should this court
Magistrate, my lord,
enter? No. You took over the possession has been given back. They have forcefully taken over the possession. You know what is to be done. Does the act provide a particular mode? Did you apply before the magistrate? And what did the magistrate
In
do?
this case, the district commissioner. Deputy
And what
commissioner
did the district magistrate do?
The magistrate appointed, the deputy commissioner appointed the executive magistrate. Executive magistrate took the possession, handed it over to us. We appointed security guards. 1 month later, Manoj, they threw out. The security guards dispossessed them and take over the forceful possession.
Then?
And in fact, Manoj, in the affidavit that the private respondents have filed, there's not even a proper denial that we are not.
No. Then what do you want from this
We
court?
want that this direction should be passed to retake the physical possession.
Absolutely no. This is not the court for doing all these things.
Because in this similar query arose on 5th of June, Manoj, I have.
Go there before whatever authority you go there.
No,
This is not the way.
Yes, we have represented, we have filed representation, but nothing has been done.
Before whom?
Before the district commissioner. Lordships will kindly have page 75 on it. First, if I may take your lordship to page 73, that is the
No. Where is that representation?
presentation is that page 75.
75.
Yes. 22/12/2022. The
Which
annexure.
is for physical possession of a secured asset of so and so, son of so and so. Fixation of the date for physical of a secured asset of so and so. Then
Manoj, again, we have filed the representation dated 27/2/2023, which is at page 77. Annexure 13.
what are these letters? Page 80 and 81?
And 81, Manoj, 80 is a representation filed by him for settlement. He wanted to settle the account where outstanding is more than 2.50 crores at a sum of 50 lakhs. That, Manoj, we have rejected by the letter dated 17/2/2023. In fact, Manoj, this is a case where RC has been issued by the DRT, where the SARFAESI application filed by him has been dismissed. Wrong back. Everything has attained finality.
Now, what does it means? How do you take over the possession once the possession has been taken?
the Similar query, Manoj, arose before, Manoj, on 5th of June also. Manoj, I would rely upon certain judgments of other high courts. If your lordship would.
No. First come to the provisions of law, not the judgments.
Section 14 is the provision.
Section 14 is for the first time.
Manoj, there is the judgments that I'm going to rely upon, so that there is.
You are now in constructive possession.
Yes.
You must have issued some letter
Letter to.
to them that you are in constructive possession. You have taken the possession. Physical possession is always subsequently.
Yes. 13/4 Manoj took place, and then after 13/4, the symbolic possession, as the lordship is saying, that exactly that. And then under section 14, we filed an application. The district magistrate, the deputy commissioner Manoj passed an order appointing an executive magistrate. The executive magistrate took over the possession, handed it over to us. We appointed security guards, a security agency, to manage the property. Manoj, on 1/10/2022, these people, Manoj, the private respondents, the borrowers, they forcibly dispossessed them throughout the security guards, and Manoj took over forceful possession of the property. Till date, Manoj, they are in possession of that property. And Manoj, we lodged an FIR immediately before the jurisdictional police. Not done anything constructive till date. We approached the Manoj, deputy commissioner that this is the situation. We have already filed an FIR. We supported it by the FIR copy. So asking for a fresh date to fix possession, to take the possession again. But there has been no reply from that. Because of that, we seek a matter. And the judgments of other high courts, the Bombay High Court, the Kerala High Court, the Andhra High Court have gone into these issues, Malord. Every case, Malord, where there is a forceful disposition, either by breaking locks or by driving out the security guards, etc. All the three high courts are unanimous, Malord, that the rule of law has to be maintained. There is no place of first application, second application. If the magistrate has taken, Malord, then the magistrate is, Malord, bound to take fix a date and take possession again. Because the possession in this case has not been taken by the bank in itself. Possession was taken by the magistrate. So it is for the violation of the order of the magistrate itself.
No, no, magistrate has taken the possession and handed it over to you.
Yes.
Then,
my lord, then my lord,
if you can't maintain the possession, then what is the?
this is a criminal act, my lord. They have criminally dispossessed, my lord. This is a case, my lord, where the rule of law, the sanctity of the rule of law has to be maintained. That is what I propose, my lord, to support by these judgments. In each of these judgments, my lord, the plea was taken by, especially by the government, that no second application is maintained.
No, I'm not on that, on the second application. But the thing that it is a possession of the magistrate. Once the magistrate take it and it is with him,
yes,
it is different. It's a different matter. But a magistrate having handed over the possession to you,
that is what the magistrate is supposed to do, my lord. Section 14, my lord, it is not for the magistrate. It is not the magistrate's duty to retain the possession. The magistrate's duty is to take it and forward it to us, along with whatever the inventory.
So the magistrate having given it to you,
yes,
don't you have to again take up a similar process?
Yes,
which you have initiated under earlier.
No, my lord, that is not required. That is
Why?
what the other high courts have held, my lord, that no fresh application. If the authorities insist that we make a fresh application, we may do so, my lord, within a week. But to avoid the formality, my lord, the other high courts have held that there is no need for a second application. Even if it be held that a second application is required, then the magistrate must take action. Because, my lord, this is a case where the sanctity of the order is violated.
No, then you again go back to the position of section 14. So under such circumstances, you again have to go back.
Well, we have,
you cannot, I don't think, for me to agree with that proposition would not be proper, taking into account that once you have been dispossessed, you want the possession on the basis of the symbolic or constructive possession in view of the action taken under 13.4. Then you have to go again under 13.4, 14.
If your lordship says so, then we may apply within a week and they will take a time-bound action. That your lordship may decide. But in the judgment that I would rely upon, this action was not held to be required. It was held that the magistrate should be appointed immediately by the district commissioner in case this comes to light. Of course, it would be for them to ascertain first whether who is in possession. So that is the order which was passed on 5/6. The district commissioner was asked to apprise as to who is in possession of the premises. And the affidavit filed by the borrowers, very cleverly, my lord, they avoid the entire question. They have not said anything. They've only said, no, we have not taken, no forceful possession has been taken. This is a case, my lord, they, my lord, have forcefully gone into the premises, thrown out the security guards, violated the law.
Let's see 14.
Yes.
Where the possession of a secured asset is required to be taken by the secured creditor, or if any of the secured assets is required to be sold or transferred by under the provisions of the Act, may, for the purpose of taking possession or control of so and so, request in writing the chief metropolitan magistrate or the DEA within whose jurisdiction any secured asset or area relating thereto may be situated or found, to take possession thereof, and the chief metropolitan, or as the case may be, the district may, on request being made into him, take possession of such assets relating thereto and forward such assets and documents to the secured creditor, provided that any application by the ER shall be accompanied by an affidavit duly affirmed by the authorized officer, the aggregate amount of so and so. Provided further that on receipt of an affidavit by the Imam, as the case may be, shall, after certifying the contents of the past suitable orders for the purpose of possession of the secured asset within a period of 30 days from the date of the application. That if no order is passed by the chief minister within the same period of 30 days, for he may, after recording, pass it. Not apply to proceedings pending before any district magistrate, as the case. District magistrate may authorize any officer subordinate it doesn't say, because I think you need to again go by that same
They
formality.
have not said anything. They have not replied even, my lord. They have not said that you apply again. That is the difficulty, my lord, that we are experiencing. If we make the, if your lordship says that, my lord, we make a fresh application within 7 days from today and they decide it within the statutory period, we are okay with that. We do not have any difficulty with that. The difficulty is that when we made the representations at page 75 and 77, they did not say that you file a fresh application. They just said we have taken, we won't go into the issue at all.
Because if we are to appreciate the judgments which you are referring to about the other high court, then what is the point of having even a security guard? You can keep it open. No, nothing is going to agree because it will be always the headache of the state or the district magistrate. Because once somebody else take over the possession, again the district magistrate comes back.
In this case, my lord, we did not keep it.
Because that it cannot be. It is not under the possession of the district magistrate. The
No, it is
possession is with
No, it
you.
is not.
So once the possession has been taken, you have to again, in exercise of the powers under that 13(4), you have to therefore take it
Not
account.
13(4), my lord, if I may say so, section 14. The affidavit, lordship has just read out the affidavit. If we are required to fulfill those formalities, then we'll do that. Within a week from today, we'll do that, and they let them decide within 30 days. But first, let them, my lords, inform the court as to who is in possession, because that was the very answer.
Yes, who was in possession?
That instructions I don't have.
Huh?
That instructions I have not received, lordship. But
Huh?
that annexure 1377, that representative is not available with the office, lordship. That annexure 13.
The matter be listed after 2 weeks, enabling the learned government advocate to obtain instruction as to the status of the complaints filed by the petitioner, that after the possession of the land in question have been handed over to the petitioners by the magistrate in terms with demand, the petitioners were dispossessed by the private respondents and violating. Let the matter again be listed. So and so assures that instructions are there. But where is that what you are asking for? There is nowhere mentioned as to who is in possession has been asked for.
That query was put to them. They were-
Query is different if it is not put to them.
If,
Because if the respondent number 4 is not in possession from whom the earlier the possession is taken, in view of that judgment of the Supreme Court wherein it says an adjudication may also be required if there is somebody else in possession. How do you take care of that situation?
Because in that case, the only method to ascertain is for the state to inform us to who it, because it will be either.
No,
I will say-
therefore, it is for the district magistrate to decide.
Gotcha.
Some 2006 or.
No, my lord, that judgments are no longer holding the court. The latest judgments are there, my lord, which has said no adjudicatory process under section 14, my lord. Time is of the essence, and the delay is not to be broken. I can place that on record.
Which one?
Listen. Adjudicatory process is no longer there. Lordship is referring to, I think, my lord, Harshad, Govind, those tenancy related matters, my lord, with the rules. Harshad Saudagar. This is my lord's latest judgment, which has declared the entire law on the subject. Para 5.1 onwards, if I may take a quote.
Yes, this one, 2014 6 SCC.
Yes, Harshad,
This was distinguished.
distinguished. because that was a tenancy related matter.
Huh?
That was a claim of tenancy.
Whatever may be, there was it is vehemently submitted by so and so, that the High Court ought to have appreciated the tenancy was subsisting and so and so, so and so. We have heard the learned counsel and so and so.
Lordship will kindly have para 5.2 onwards.
And if I'm not wrong, this Harsat matter was a three judges bench.
Well, that is pre-amendment of the SARFAESI Act. 2016, Lordship may recall the Vishal Kalsaria judgment, which is also cited in this. Kalsaria was a division bench judgment. Justice Amitav Roy said that the tenancy, if there is a clash between the State Tenancy Act and the SARFAESI Act, then the Tenancy Act would prevail to that extent. And the tenancy, if there is a tenant in the premises, he would be.
I'm not on the tenancy business. The adjudication, you are just for example,
Yes.
here what the Supreme Court has said is one way. Just for example, if this judgment is to be followed, you file an application, he will. Today, he may not be a secured creditor. You may not have taken any action against anybody. Merely because it is a secured asset, you can just take over, but whoever may be in possession.
Gotcha.
But if the judgment in the case of maybe of a case of tenancy, but the principle out there is different.
If I may.
And therefore it says that civil court may not have a jurisdiction of the, but however, they will look into it and thereafter they can very well come under 226.
Yes, that is pre-amendment of 2016 with effect from 1/9/2016. The SARFAESI Act stood amended and say section that 17.4 has been brought into play.
What is 17.4?
17.4A, 17.4 and 17.4A.
No, 17.4 is a different aspect. But here, 14 have not been touched.
No, it is not necessary to touch. If I may just be permitted to read para 5.2 on the Lordship, the entire issue will become clear.
Where?
So there is a line of judgments. Lordship will kindly have para 5.2 on it.
5.2,
page 5, internal page 5. On a fair reading of section 14 of the SARFAESI Act, it appears that for taking possession of the secured assets in terms of section 14(1) of the SARFAESI Act, the secured creditor is obliged to approach the district magistrate by way of a written application requesting for taking possession of the secured assets and documents relating thereto and for being forwarded to it for further action.
Let me come back and find out, look into this aspect of the matter pertaining to this judgment also. Get this judgment out. This Nausat thing, Harsat Govindan, 2014, 6 SCC 1. How many judges were there? Because 14 has not been amended. No. Now, any person else can very well go. 17.4 brings in that any other person will. Yeah, lessee can. That is very well.
That was the issue which arose in Harshad Sodagat also. And that was the crux of the issue in Vishal Kalsaria because Justice Amitav Roy's judgment held that the Rent Act would prevail and the tenants would stand.
No, that is another aspect. But
in
as
Harshad
regards the
Sodagat,
second last portion of this Harshad judgment,
I'll bring that.
Can you come to paragraph number 29?
Here it is. Subsection 3 of section 14 of the SARFAESI Act provides that no act of the chief metropolitan magistrate or the district magistrate or any officer authorized by the chief metropolitan magistrate or the district magistrate done in pursuance of section 14 shall be called in question in any court or before any authority. The SARFAESI Act therefore attaches finality to the decision of the metropolitan magistrate or the district magistrate, and this decision cannot be challenged before any court or any authority. But this court has repeatedly held that statutory provisions attaching finality to the decision of authority, excluding the power of any other authority or court to examine such a decision, will not be a bar of the High Court or this court to exercise jurisdiction vested by the Constitution, because the statutory provision cannot take away a power vested by the Constitution. With the quoted part, in our view, therefore, the decision of the chief metropolitan magistrate or the district magistrate can be challenged before the High Court under Articles 226 and 227 of the Constitution by any aggrieved party. And if such a challenge is made, the High Court can examine the decision of the chief or the district magistrate, as the case may be, in accordance with the settled principles of law.
And just before that, in paragraph 28,
Yes, 28
last,
is the relevant part.
when such an application is filed, the chief
Yes.
metropolitan magistrate or the district magistrate will have to give notice and give opportunity of hearing to the person claiming to the lessee as well as to the secured creditor consistent with the principle of natural justice and take care. Magistrate or the DI is satisfied that there is a valid lease and so and so and then. But the question is,
I mean,
if understand everything, but if it is a case where some right is there to say that they will just perform a ministerial function,
that is what the Supreme Court is.
when the Act gives a particular power, and there is and also says that the decision would be final.
Of course, they can challenge it before the DRT or before the court also in Article 2, under Article 226.
No, the decision of under 14 is final.
No, 14 is final to the extent they cannot challenge it nobody can challenge it in a court of law. That would be restricted to the lower, the subordinate judiciary. That is what Para 29 states, that article in the High Court or under Article 226 or 227 as the case. They may approach, because the writ court's power is beyond.
No, therefore, the only but when a decision is made final, don't you think there is a necessity of natural justice?
No, natural justice, as far as Para 28 of Harshad is concerned, that is stated only as far as the lessee is concerned.
No, not lessee, but whenever a statutory enactment says a decision, how they say, but there is a word used out there in 14.3 that is a decision.
Yes, decision. And
If
that,
it is a decision, can it be said to be a ministerial act?
that is what the Supreme Court has said, and not one, but a number of judgments. And I have all those judgments which I have brought notes, that the adjudicatory process, it is not neither adjudicatory nor even quasi-adjudicatory. It's a ministerial act and time is of the essence. No delay is to be proved. And if the application is found in order, the district magistrate only has to ascertain whether the contents of the application are correct to that extent and pass the order. So that is why the time period is prescribed. That is what Balkrishna says. That is what the other judgments which Balkrishna relies upon, coordinate benches of the Supreme Court. I have those actually. If I may take your lordship to Balkrishna only first before going.
No, Balkrishna, I've seen it.
Lordship.
Okay, but the thing is, this court is troubled with the fact that when you are making the statutory enactment says about the decision being final, since there is a requirement of an adjudication, how can there be a decision without an adjudication?
In this case, that is what the apex court has said. That section 14 there is adjudication. So the adjudication, my lord, in my humble submission, is to be done not by the DM, it is to be done in any case, my lord, by the DRT. He is free to challenge the order under section 13.4. He is free to challenge section 14 order.
But
under section 17.
No, but 14 order cannot be challenged on the 17.
But now, my lords, it can, because this
Show me that.
Harshad, my lords, if I may say so, is pre-amendment. The act was amended with effect from 1/9/2016.
Where does it say that the decision is filed in this section 15?
But section 14 knows. But subsection 3 minutes. Subsection 3 of section 14. No act.
Here it says no act of the so and so done in pursuance to this section shall be called in question in any authority. It doesn't refers to a decision.
Act. No, this is more of a, Lordship is aware of, this is more like an indemnity, my lord, that. it
No,
will-
but the
Good
word used out here in this judgment in Harsad, it refers to as a decision.
Yes. But Harshad has to be taken, my lord, considered in the light of the pre-amendment situation, because Harshad was dealing with the case of lessees. Parliament has addressed that.
Whatever may be, paragraph 28 may say about it, but here it says kindly see, the decision is final.
Yes, because this was dealing with the aspect of lease.
So therefore attaches finality to the decision of the year.
Yes.
The word at paragraph 29,
That's
decision. Decision is a different from an act.
it cannot, this cannot be read with 14.3 in the context of 14.3. It is in the context of the decision itself.
No,
14.3
if
is
it
more
is
like
a, if it is a decision, it becomes different.
yes. But this has to be considered in light of the pre-amendment position. my lord. Because on 1/9/2016, the act was amended, the lessees were given substantial.
What about the lessee? I'm not on that. Well, on the principle.
No, other than the lessees, nobody else is protected. my lord. That is my humble submission. Other than the lessees, under section 17, anybody can challenge it. He can also go and challenge that physical possession order.
No,
This
but
was
he
the-
cannot challenge the proceedings under 14.
No.
If it is a decision, he cannot challenge. He can only come before this court.
He has that.
So he can only come before this court against an order under 14.
I cited in that other case, Agarwal Tracom, Lordship has put that civil revision judgment in which the Supreme Court had interpreted everything done under section 13(4) or the measures under section 14 also, all will come under section 17(2). The DRT has jurisdiction. If anybody wants to challenge the order of the DRT, that judgment I had submitted my lord, in that case.
But then if that be so, wouldn't that be in contrary to this thing? Shall not be called in question in any court or before any authority. Authority would be the section 17.
Court, my lord, in this case, the tribunal has been given the sufficient jurisdiction.
Understood, but how do you take care of it? Section 14(3) says not to any court or any authority.
But then Lordship will kindly come to section 17 for a minute. That is what the amendment has given that sufficient power, my lord, in the case of the lessees, my lord.
Yes.
Because otherwise, no person would be able to make any application.
The tribunal shall consider whether any of the measures ordered under so and so by the so and so enforcement are in accordance with it. But this is under 13(4).
13(4) and my lord, as far as 4A is concerned, because this 4A was brought into force with effect from 1/9/2016. This is pursuant to Vishal Kalsaria and Harshad's judgments.
No, understood. This is another aspect of the matter. But the 14 proceedings can only be challenged in a 226.
Could have, my lord, come forward.
No, it's a different thing. I'm not on that. I'm not. But there would be a difference, but if it is not a decision.
Good.
If it is not a decision, but it's only an act.
Act, my lord, let us say.
Act
yes,
does not require
act
anything.
of taking possession, my lord. That is, I think that is the act.
It is an act. Because the provision says to be an act. However, in this judgment, it was mentioned to be a decision.
Yes.
When it is a decision, you need an adjudication.
Yes. But,
That is the difference.
Supreme Court in the latest line of judgment has said that this decision is a ministerial act.
No, it is therefore, the Supreme Court have taken it as an act, which has a complete different connotation from there.
Yes.
Anyways, sure. Yes, response number 4. Are you in possession?
Lordship, Well, the facts of the case is that your lordship, at the time of the loan, I had.
I'm not on the loan business. Are you in possession?
Your lordship, there is a civil suit pending regarding.
I am only asking you, are you in possession?
As per the instructions received by me, I am not in possession because the house which I have constructed was in the year 2008.
You are not in possession. You will file an application. You file a fresh application under 14. You hand over the possession. Heard Mr. A. Ganguly, the learned counsel, appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent numbers 1, 2, and 3. You appear for 4 and 5. Mr. So-and-so appears for the respondent number 4 and 5.
Your lordship, I am appearing for 4.
4. Who is for 5?
Your husband and wife.
Husband and wife. Okay. Appears for 4. It is also taken note of that the respondent number 5 is the wife of the respondent number 4. Petitioner herein have approached this court being aggrieved by the inaction on the part of the district magistrate to take action in terms with section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, for short, the Act of 2002. The facts, as can be discerned from the materials on record, is that the respondent numbers 4 and 5 had taken a loan, had taken financial assistance from the petitioner bank. Upon failure on the part of the respondent number 4 and 5 to make payment, the account of the respondent number 4 and 5 were declared to be non-performing assets, and subsequently steps were taken in terms with the Act of, in terms with section 13 of the Act of 2002. The petitioner further, while taking steps under section 13(4) of the Act of 2002, issued a possession notice over a plot of land which was a secured asset. Which is the plot of land?
So the description of the property is given. The application.
The plot of land in question is which one? House number 76.
Yes.
Huh?
Yes.
Sure.
I'll just verify. Yes, that is that description is at page 70.
House, the plot of the secured asset was house number 76, holding number 3636, comma, First Link Road, Main, comma, Ward number 16, Silchar, district, in the district of Kachar, 788006, Assam. And was which plot?
Both of house number 336 situated at First
Here's
Link.
your application. You file that application, no?
That application is not available. Only the order copies there. Page
Huh?
7.
Where's your application?
Application is not on record.
Huh?
That application is not on.
Page
Page 70 is the order. Page 70 is the order. Passed.
70.
Yes, order passed under section 2.
The property in question, this one, no? The property in question is all that part and parcel of the house number 76, comma, holding number 336, situated at First Link Road, Main, comma, ward number 16, Silchar, standing over a plot of land measuring 8 kathas, 18 gondas, covered by dark number 113, patta number 27, at Pargona, what is that? Kanakpur, Moza, Kanakpur, Part 2, Silchar, Kachar. Pusto. Pursuant to the issuance of the possession notice, whereby symbolic possession was taken by the petitioner bank, the petitioner bank approached the respondent number 2 in terms with section 14 of the Act of 2002. The respondent number 2 thereupon had taken action and handed over the possession of the said secured asset to the petitioner bank. It is the case of the petitioners that subsequent thereto, that the petitioner bank, after taking over possession over the land, over the secured asset, had maintained certain security guards and kept it under their possession by keeping certain security persons. However, it is alleged that the respondent number 4 and 5, with their persons, have forcefully taken over the possession of the land over the secured asset. It is under such circumstances, various applications were submitted before the. It is under such circumstances, an FIR was filed before the officer in charge of Silchar Police Station, which was registered and numbered as Silchar PS case number 2302/2022 under section 120B/448/188 of the Indian Penal Code. In addition to that, the petitioner bank also sought the assistance of the respondent number 2 and 3. 2 and 3, na? For two, for again taking over the possession by submitting certain representations. However, as the said respondent number 2 did not take any steps, you only approached the executive magistrate, not the district magistrate.
So in page 77, we have approached the district magistrate also, the then district magistrate.
But as the respondent number 2 did not take any steps, the petitioner has approached this court by filing the instant writ petition. This court, pursuant to filing of the instant writ petition, issued notice on 22/11/2023 on various dates, various instructions have been sought for. However, nothing has been placed before this court on behalf of the respondent number 2 and 3. You filed an affidavit, na? Yes. It is, however, noticed that the respondent number 4 and 5, respondent number 4 had filed an affidavit in opposition on 1/8/2024. In the said affidavit in opposition, it has been mentioned that a suit was filed, has been filed by the you filed, has been filed by the respondent number 4 before the court of the, which court?
Civil judge number 1.
Huh?
Civil judge
Before the court of the civil judge number 1 Kachar at Silchar. Which have been registered and numbered as title suit number TA number 163/2022, along with an injunction petition being Mizze case number 205/2022. It has been further mentioned that in the said injunction application, which is Mizze case number 205/2022, the learned trial court, that is the court, the learned trial court, that is the court of the civil judge number 1 Kachar, had issued an order on 29/9/2023, thereby appointing a local commissioner to conduct such investigation and submit a report to the court as to whether the building in question in the suit property or in the mortgage property, whether the building in question is in the suit property or in the mortgage property of the bank.
3 months.
Huh?
29/3/2023 months.
29/3/2023.
9/9.
However, there is nothing mentioned as regards issuance of any injunction order. Mr. I've heard the learned counsels appearing on behalf of the petitioners. Mr. A. Ganguly, the learned counsel appearing on behalf of the petitioner, on behalf of the parties. Mr. A. Ganguly, learned counsel appearing on behalf of the petitioner bank, submitted that the petitioner, that as the petitioner bank was dispossessed pursuant to an order passed by the respondent number 2 and handed over the possession, whereby submitted that as the petitioner bank was handed over the possession of the secured asset on the basis of an order passed under Section 14 of the Act of 2002, the respondent number, and thereupon having been dispossessed, the respondent authorities, more particularly the respondent number 2, ought to have acted on the representation so submitted by the petitioner. He further drawing the attention of this court to the judgment of the Supreme Court in the case of Balkrishna Rama Tarle Dead 2 LRs versus Phoenix ARC Private Limited and others, reported in 2023 1 SCC 662, submitted that the respondent number 2 is bound to take an action upon being satisfied when an application is filed under Section 14 of the Act of 2002. Referring to the paragraph number referring to paragraph 15 and 16 of the said judgment, the learned counsel appearing on behalf of the petitioner submitted that the respondent number 2 is bound to or was bound to take action when the petitioner have duly approached by submitting a representation. The learned counsel for the petitioner bank further submitted that as a statutory duty had been conferred upon the respondent number 2 to act, and there is a failure to act, the petitioner have therefore, bank has therefore approached this court seeking a mandamus for issuance of appropriate directions. Mr. N. Goswami, anything else? Mr. N. Goswami, the learned counsel appearing on behalf of the state respondents, submitted that he has no instructions.
The second application, Lordship, you had not received the application, Lordship.
Huh?
The application he has filed in 27 to 23, that is not in our office, Lordship.
Submitted that the application by which the application by which the petitioner bank had approached the respondent number 2 is not available in the records of the respondent number 2. He, however, submitted that the petitioner, if so aggrieved, ought to have filed an application in terms with Section 14 of the Act of 2002 rather than submitting a representation. Mr. So-and-so, appearing on behalf of the private respondent number 4, submitted that a suit is pending as regards the identity of the mortgage property. He further submitted that an injunction application has been filed. However, he duly submits that there is no injunction order passed. Rather, only an order has been passed for appointment of a local, for making a an order has been passed for local investigation in terms with Order 39, Rule 7 of the Code. This court, upon hearing the learned counsels appearing on behalf of the petitioners, put a specific query upon the learned counsel appearing on behalf of the respondent number 4 as to whether the respondent number 4 is in possession of the secured asset. The learned counsel submitted that as per his instruction, the respondent number 4 is not in possession of the secured asset. In the backdrop of this above, let this court take into consideration the respective submissions. It is seen from a perusal of the Act of 2002 এই দাদা কবজুল এখন ভাল কিতাব দিবলে এখন ভিডিও দেখাই না পায় দেখাবে তুমি নাটকে পড়ব that upon the failure of the borrower to comply with the notice as given under Section 13(2) of the Act of 2002, the secured creditor has been given various have been empowered to take various measures to recover the secured debt. Amongst the various measures, one of such measure is to take possession of the secured assets of the borrower, including the right to transfer by way of lease, assignment or sale for realizing the secured asset. This power can be traced to Section 13(4) For the purpose of enforcing for the purpose of taking steps in accordance with Section 13(4)(a), the secured creditor have also been the Act of 2002 also gives liberty to the secured creditor to approach the chief metropolitan magistrate or district magistrate to assist the secured creditor to take possession of the secured asset. This power can be traced to Section 14 of the Act of 2002. This court have also perused the said provision of Section 14. And it appears from a reading of the various, from a reading thereof, that for taking possession of the secured asset in terms with Section 14(1) of the Act of 2002, the secured creditor is obliged to approach the district magistrate or the chief metropolitan magistrate by way of a written application requesting for taking possession of the secured assets and documents relating thereto, and for being forwarded to it for further action. it is further seen that the said application is required to be accompanied by an affidavit giving due and affirming to the mandate as stipulated in clauses Roman 1 to Roman 9 of the first proviso to section 14(1). Upon such an application being filed, a statutory obligation is enjoined upon the Chief Metropolitan Magistrate / the District Magistrate to immediately move into action under Section 14(1) of the Act of 2002 from the secured creditor for that purpose. This court further takes note of that the district magistrate or the chief judicial metropolitan magistrate, as the case may be, is required to be satisfied with the contents of the affidavit and pass suitable orders for purpose of taking possession of the secured assets. And it is further mentioned that the said order is to be passed within a period of 30 days from the date of the application. The third proviso to section 14(1) further provides that in the circumstance the chief metropolitan magistrate or the district magistrate is not in a position to pass the order within 30 days for reasons beyond his control, the said official shall duly record reasons in writing for the same and pass the order within such further period but not exceeding in aggregate 60 days. This court finds it very pertinent at this stage to refer to paragraph number 18 of the judgment in the case of Balkrishna Rama Tarale, which, being relevant, is quoted herein and reproduced herein under. A perusal of the above quoted paragraph would show that once all the requirements under section 14 of the Act of 2002 are complied with or satisfied by the secured creditor, a duty is cast upon the district magistrate, the respondent number 2 herein, to assist the secured creditor in obtaining the possession as well as the documents related to the secured assets, even with the help of any officer subordinate to him and or with the help of an advocate appointed as an advocate commissioner. Pusto. This court also finds it very pertinent to take note of Section 14(2), which further empowers the district magistrate, bracketed the respondent number 2 herein, to take or cause to be taken such steps and use, or cause to be used such force as may, in his opinion, be necessary. This would also, the above analysis of Section 14 would therefore show that once the compliance, if due compliance is made under Section 14(1), by submitting the application along with an affidavit in terms with the first proviso, and a duty is cast upon the respondent number 2 to take such action as stated in the said section. This court, however, takes note of that a perusal that pursuant to the dispossession of the respondent of the petitioner bank, the petitioner the dispossession, the petitioner bank have not applied for, the petitioner bank had only submitted a representation. However, in the opinion of this court, that when the statute categorically mandates that the power to be exercised by the district magistrate is subject to the satisfaction on the basis of the documents, on the basis of an application supported by an affidavit, giving details as stipulated in the proviso, first proviso, the petitioner bank is therefore required to file an application in terms with Section 14(1) for the respondent number 2 to act in terms with Section 14, in terms with the mandate of Section 14. The statutory obligation so cast upon the respondent number 2 would only arise upon due compliance by the petitioner bank in terms with Section 14(1) of the Act of 2002. Accordingly, this court therefore disposes of the instant writ petition, thereby granting liberty to the petitioner bank to file a fresh application in accordance with the provisions of Section 14(1), and upon such application being filed, the respondent number 2 upon being duly satisfied shall pass necessary orders within a period of 30 days from the date of such application and not later than 60 days. This court further directs that in the circumstance the respondent number 2, further directs that the respondent number 2 can use such force as in his opinion necessary for the purpose of assisting the petitioner to get the possession of the secured asset. With the above, the petition stands disposed.
the past, that may not be treated by them as a bar to entertain.
Huh?
In order that they were, we already passed an order earlier, that they may not treat it as a bar to the second application.
Why do I need to say? I've directed them to do it. You file your application. Why do you want to make things complicated?
Number 1.
Now we understand. What about payment?
Here, the chief engineer has submitted that the funds will be moved as soon as possible.
When?
That time frame they usually don't give, Lordship, because they cannot stick to.
Huh?
It is in process. Lordship. The payment is in process.
When? That is the direction I gave, na? Has already been completed and some amount have already been paid and the rest would be paid within a time frame. That is why that was my direction to file an affidavit. That is the affidavit I asked for. Not satisfactory affidavit.
They have done nothing, my lord. They have annexed one document in the affidavit they have filed. This document is already annexed in the requisition, my lord. This revision report was done long back in the year 2020, your lordship. After making part payment, my lord, the requisition was filed. But the amount to which the petitioner is entitled, your lordship. After direction of this honorable court, they have done nothing.
I think this is a fit case for issuance of contempt proceedings against this person. Chalo. Issue notice making it returnable on 21st of August 2024. The affidavit today, an affidavit has been filed by the respondent. Under such circumstances, filed by the respondent through who has filed this?
Chief engineer.
Huh?
The chief.
No. Filed by the respondent through what is his name? It is not clear who has filed. What is that lawyer name? Who has filed this? Through Mr. R.R. Gogoi, advocate. Under such circumstances, it is presumed that the respondent number 1, that a respondent has due notice of the instant proceedings. The instant contempt application is filed on the ground that the respondent herein have willfully and deliberately violated the order passed by this court on 21/7/2023 in WPC number 2144/2022. Whereby there were certain directions passed to complete the verification within 3 months and to make payment in terms with Tamser Ali versus State of Assam and others, reported in 2008 4 JLT, page 1. When the matter was first listed before this court sought instructions from the Standing Counsel of the PHE department as to why the order passed by this court have not yet been complied. Biden order dated 15/7/2020. And accordingly directed that the matter be listed on 22nd of July 2024. On 22nd of July 2024, no instruction came from the PHE department, and time was sought, and accordingly this court fixed the matter on 26/7/2024. On that date, the Standing Counsel appearing of the PHE department had submitted that verification have already been completed and some amount have already been paid, and the rest of the amount would be paid within a time frame. In view of the said statement being made by the Standing Counsel of the PHE department, this court directed that an officer of the PHE department not below the rank of a chief engineer to file an affidavit in that regard. Accordingly, an affidavit has been filed by the respondent herein today. From a perusal of the said affidavit, it is mentioned that the executive engineer PHE Dhubri division had already paid an amount of rupees 1,27,500 and an amount of rupees 4,25,286 was balanced to be paid to the petitioner. It has been also mentioned that due to paucity of fund, the same could not be paid to the petitioner. It, however, astonishes this court to take note of that the verification which have been the verification so made as stated in the affidavit is in terms with Annexure A to the affidavit. A perusal of the said affidavits, a perusal of the said Annexure A shows Mr. M. A. Rahman, the learned counsel appearing on behalf of the petitioner submitted that this Annexure A was a part of the writ petition. And as such, the affidavit which had been filed is nothing but an eyewash to the effect that there was any verification carried out. Be it as it may, this court duly takes note of that it is an admitted fact that an amount of rupees 4,25,286 is payable to the petitioner, and the amount of rupees 1,27,500 have already been paid prior to filing of the writ petition. The respondent authorities, the respondent, in our opinion, in the opinion of this court, cannot delay the payment at its sweet will, more particularly taking into account that these bills pertain to the year 2014 and the last of such bill is of the year 2018. Full stop. Under such circumstances, on the next date, the respondent herein is directed to apprise this court as to whether the amount of rupees 4,25,286 have been disbursed to the petitioner, and if not, when would it be done? Full stop. The statement of paucity of fund, in the opinion of this court, cannot be a good ground to deny the entitlement of the petitioner, more so when there is already a judge order passed in favor of the petitioner. Full stop. List the matter again on 11th of September 2024.
Okay.
I've given you enough time. Find out the money. Get the money from Mr. D. Gogoi. He has a lot of money. And then get paid.
Plus,
No, 21 notice con 11. 11 to go. 11.
my name is not reflecting in the call list.
Your name, Mr. A. Rahman's name. Get the money from him.
$17.
Yes, what is this?
My lord, before my learned friend starts, my lord, I have just been instructed to appear on behalf of the respondents 6 to 8. I need some accommodation, my lord. If it can be taken up after some time, maybe after a week. They find that, my lord, the affidavit of the government is also not there. Otherwise, so far as the pleadings of the private parties are concerned, that is complete.
Who is now running as the chairman?
He is not a party here in this proceeding.
He subsequently elected, Lordship.
Now you have challenged the chairman. You were earlier the chairman.
I was the earlier chairman.
You have not only been removed, you were not only removed from the chairman, you were removed, your membership was also terminated. I state that.
Membership per state, Lordship.
But not the
is
chairman.
subject to outcome, Lordship.
Yes.
This matter is only on law point only, Lordship. On
2012, 2023, 6 months. How much time does he have normally? When were you elected?
I was elected on Lordship 39/2022, Lordship.
5 years. Chalo. Affidavit is filed.
Yes, my lord. So far as the private parties are concerned, the pleadings are complete.
Then what is left?
Only the government is yet to make a stand.
No, government, Mr. Talukdar is enough good for making submissions. He doesn't, he only says that I will only argue on a law point.
Correct.
So now, let us start.
If your lordship kindly takes it up on 13th or 12th, any day in the week commencing 12th.
Why?
12th of August. Any
Today
day.
I have the list of the matters. 37 matters only.
Well, I just got the instructions yesterday night. Lord. That
You are a senior counsel, they don't require instruction. They get instructed, briefed out there on the corridors of the court.
Only thing is that, my lord, your lordship's order I have seen, whether the impugned order is in the light of the provision of Section 47 read with Rule 20, Section 41 read with Rule 27, or it's an order in pursuance of the previous order of this honorable court. That is the area of your lordship's examination that your lordship indicated in the first order. Well, I need some instructions. I need to go through the previous orders in detail because the kind of pleadings that were filed in the previous the previous proceeding that I have not gone through.
Why do you need to go? You'll be assisted by somebody who will be informing.
Well, the order which the honorable court had passed as the first instance, based on which the inquiry has been conducted. Now, their contention is that they had filed an application we had filed an application for cancellation of nomination. And it is a fallout of that application, and therefore the rule section 41 gets attracted. And since it was not filed within a period of 3 days, so it fails. That is the kind of stand that they want to project.
Mr. S. Dr. Dillon is senior counsel appearing on behalf of the respondent, private respondent, seeks for an accommodation. Stop. Taking into sorry. Stop. List the matter urgency. No. List the matter on 4th of December 2024. Interim order passed earlier shall continue till the disposal of the requisition. Yes, what is your stand, government?
It was, construction was by the committee, construction committee of the Anganwadi Center, and the minimum requirement of space is 1800 square feet.
That I understand. He is asking that there should be an Anganwadi center. Isn't it?
That's right.
At 167 number Irarigul Estate. Directing respondents to set up model at 165 number Iragul Estate and Ahmedpur Anganwadi Center. What has happened to Iragul? The committee for 165 area was notified. Members of area visited both sides of Anganwadi on 410 and selected the place where new Anganwadi is being constructed. Found that the present site is not suitable for model area and does not possess the required. The committee took a resolution for construction. Committee further states that the director, woman so and so, with a letter to all the DSPOs who have been in mind. Then what happened?
Then construction, whether it started or not, it's not there. But that earlier place was not suitable.
No, you are saying something of the year 7/2/2000, of the year 6/7/4/10/2023. In the year 2024.
Right.
But don't you give an update? What has happened?
You have to get it.
The BJ Talukdar, the Learned Council appearing on behalf of the will obtain instructions as to what steps have been taken for construction of the Anganwadi centers pursuant to the decision to construct the model Anganwadi center at a new place, which is within the jurisdiction of Eralitul Tea State. It's the matter again on 2nd of September 2024. And appears on behalf of the petitioner on call. And appears on behalf of the petitioner as well as the respondents on call. Yes, what have you done? This has been mentioned.
20.
Is your lordship. Lordship, the matter pertains to levy of GST on the Assam Regulatory Commission, lordship. Some Electricity Regulatory Commission, lordship. My case is that, lordship, the Regulatory Commission acts like a civil court according to the Assam Electricity Act 2003, lordship. Thus, the trappings of court and its functions are like of adjudicating like a court. Therefore, the GST which is the respondents want to levy on it, that is not correct.
What?
Lordship, they are trying to levy GST on the petition fees that is collected by the Assam Electricity Regulatory Commission.
Or what fee?
Petition fees, lordship.
Petition fee.
Petition, because they decide who has to get the license, who will not get. They adjudicate, lordship. It is established under Assam Electricity Act 2003, lordship. And section 95 of Assam Electricity Act says that it has the trappings of the court. The proceedings under the proceedings that they conduct, it is to be conducted under IPC and CRPC, lordship. So the lordship, section 95 of.
What are you telling me? I'm not getting it. There's an order passed.
Yes, your lordship.
What
There
is
was an
that order?
passed. Then we approached this court.
Let us see where is the order. This order in original.
Order in original, lordship, is at page 144, lordship. 27 to.
Yes, what does it say?
Lordship, against this order, we had preferred a writ petition before this court, lordship.
I confirm a partial demand of GST amounting to 2 crores so and so for reasons discussed in para 11 subpara 9. I confirm the. You are challenging the 27 to 2023.
No, lordship. In this petition, I'm not challenging that.
What
That
you are
order was-
challenging?
Lordship, I may submit, lordship. That order was passed. Then we filed a writ petition before this court. This court has stayed that order, suspended that order. That is at annexure 10, page 176, lordship.
170.
176 it starts, lordship.
76.
The operative petition is 179, lordship.
Then
This was stayed, lordship. In the interim, this order shall remain suspended till the next day.
Then,
lordship, what happened is the principal commissioner asked the additional commissioner to file an appeal in that same order in original 27-2, which was stayed by this court. The principal commissioner advised the additional commissioner to file an appeal before the appellate authority. Then appellate authority passed an order enhancing our demand, lordship. Against that order, we are before this court, lordship.
enhancing your demand.
Yes, your lordship. During the when the stay was operating in this court, lordship, that order, lordship, will find at page 191. 13
Okay,
to
where are the other 2 writ petitions?
Yeah,
All the other writ petitions.
not listed.
Yes, Mr. B. Gogoi.
Well, here regarding cancellation, I've got the instruction today. during the course of the day. I will file
Lordship,
one
in
short
this case,
affidavit.
Lordship, I think there is some mistake. He's not there.
Huh?
It is AES.
Sorry.
No, he will be there.
22.
This is only about central GST, Lordship.
No, it can be. Kindly see this, page 173. 173. I confirm a partial demand of the GST amounting to so and so, CGST Iman and SGST Iman. Then why he would not have anything?
Lordship, the main person who has passed this order, this is a CGST authority, Lordship.
This order?
Yes. Additional Commissioner, CGST Department. Lordship. And the next order also has been passed by the Commissioner Appeals of CGST Department, Lordship.
And how can the Commissioner Appeals for the CGST Department confirm a SGST order? It can.
Both components are same, Lordship. That's why. Components, they're calculated together only, SGST and CGST, Lordship.
I confirm the proposal for realization of interest on the so-and-so at the rate of in terms of 50 and corresponding section of so-and-so. Yes, who is there for the central GST?
Lordship, I have already taken seeking instruction on 14/6/2024 on the part of the grievance by the petitioner.
Huh?
I have taken instruction on 14/6, but I have not received any instruction till date, Your Lordship. So I have mentioned in 14/6/2024.
Okay. And again, the instant writ petition is connected with 3 other writ petitions, being WPC number 4376/2023, 4841/2022, and 4842/2022. The instant writ petition, along with the other 3 writ petitions referred to above, be listed again on 23rd of September 2024. The interim orders passed earlier shall continue till then. It is also seen that the respondents have not filed their affidavits.
In one matter, they have filed, Lordship, in the previous.
Not here.
Not in this.
In the instant proceedings. The respondent are directed to file their, are given the liberty, a final liberty to file their affidavit on or before the next day.
21.
Service tax, Lordship, time barred, Lordship, SOCO's notice, time barred order.
Huh?
Time barred, SOCO's notice and time barred order, Lordship.
Time barred?
Lordship, in the service tax, Lordship, under the Finance Act 1994, Lordship, if they issue me any SOCO's notice, it is for the year 2015-16. Then the Lordship notice has to be given under the provision of Section 73 within a period of 30 months. That can be extended up to 5 years if there is a fraud misrepresentation. They have invoked the extended period of limitation. So if they invoke, if that is correct, Lordship, till 5 years they are allowed. So within 5 years they have issued me the notice. But then, Lordship, after that, if they want to file if they want to pass an adjudication order, then that has to be passed within a period of 1 year. That they have not done. They have passed the adjudication order after 4 years, Lordship, of the giving of the SOCO's notice. So, Lordship, that is barred by limitation under the provisions of Section 73(4) of the Lordship Finance Act. 73(4)(b).
60?
73(4)(b). Lordship, it's page 18. Section 73 starts at page 16. Finance sector topic.
Will determine the amount of service tax due and 1 year.
It says lordship maximum 1 year. For B lordship, page 18.
And in this case,
And lordship, so current, in this case, lordship, the order has been, the so-called notice was lordship issued to me on 19/10/2020. It has page 66. And they have issued me the impugned order on 27/3/2024. Almost 4 years, lordship.
yes,
Page 90 is our stand, your lordship.
page
90.
90.
Why you have issued this section 73 of subsection 1? That is there in the page 90 also.
90.
Yes, lordship.
Yes.
On
Which
the top.
paragraph?
1.4 is the for paragraph. Why you have issued
There is the
subsection 7?
notice providing to external being aware. No, okay. Understood. For that suppression of material facts, whatever may be, you had the power to do as the per the first proviso to subsection 1, which gave you 5 years. You issued a show cause notice on 19/10/2020. Why did you pass an order after 4 years? What is your explanation there? That is her case, nothing more than that. What is your explanation to that? The Gogoi,
Lordship,
you have
the-
taken the case very lightly.
no, lordship, page 90, the summary of the conclusion, why they have is invoking the jurisdiction.
Understood. Everything understood. That and thereby, whatever may be, you get a period of 5 years. You have taken that 5 years. 2015-16, you have taken that 5 years, and that 5 years, you have issued the notice on 19/10/2020. What happens thereafter? How do you take care of section 73(4)(b)? You are supposed to pass the order within 1 year. If they don't give, then also. But why did you wait for another 4 years?
And it also, Lordship, I'm a subcontractor, I'm exempted from payment of service tax.
Huh?
I,
Who are you?
I'm a subcontractor, Lordship. I'm exempted from
Not
payment
on
of service tax.
that, but anyways.
So cause notice is also barred by limitation, but I'm not into that. This will
No,
suffice.
so cause notice is within time.
If they have, Lordship, invoked the extended period of limitation, but since I am an exempted unit, they could not have done because I'm an exempted person. I'm exempted from payment of service tax because I am working under a contractor who is working under the government. Subcontractor, because what they have done is that they thought that since I am working under the contractor who is working under the government, I'm not.
Let us not go into those things. These are questions of facts. Then the moment you are saying all these things, should I refer you to the appeal?
That
Go and file
that
appeal.
is why, Lordship, I'm not.
Huh? File an appeal.
That's why I'm not.
When to file an appeal, very well. Question of facts, should I say, much easier for me. Yes. Yes. Huh?
If Lordship permit me take instruction, I have already making instruction to my department on 1/7/2020.
Your department is not helping.
Let me.
Department is not bothered. I think the department has got a lot of money. So why should they be bothered with this paltry amount of how much? 41 lakhs. Another 41 lakhs. Another 41 lakhs. 1 crore, 23 lakhs. Whatever instruction you have to get it. I'm otherwise allowing the petition. The instant petition has been filed by the petitioners. Heard Mr. Miss N. Earlier, the learned counsel appearing on behalf of the petitioner, and Mr. Ian Gogoi, the learned standing counsel of the CGST. The petitioner herein have challenged the impugned order in original dated 27/3/2024 on a question of jurisdiction of the authority to pass the order or pass the impugned order in view of the provision of section 73(4)(b) of the Finance Act 1994. It is the case of the petitioner that the impugned order relates to the assessment year 2015-16. Further to that, referring to section 70 of the 73. Referring to section 73(1) of the Finance Act of 2024. The learned counsel appearing on behalf of 1994. The learned counsel appearing on behalf of the petitioner submitted that for the purpose of issuance of notice in respect to service tax which have not been levied or paid or have been short levied or short paid or erroneously refunded, the Central Excise Officer had to issue a notice within, show cause notice within 30 months from the relevant date the person chargeable with service tax have not been levied or paid, or which have been short levied or short paid, or the person to whom tax refunded have been erroneously made. The learned counsel, appearing on behalf of the petitioner, further submits that the first proviso, the proviso to subsection 1 of section 73, categorically mentions that in certain circumstances which have been enumerated in subclauses A to C, E, the Central Excise Officer can issue the notice within 5 years instead of the 30 months as stated in subsection 1 of section 73. The learned counsel submitted that appeal from the materials on record that in the instant case, the so-called notice was issued on 19/10/2020. Further referring to section 73(4) capital B, the learned counsel submitted that capital B, the learned counsel submitted that the Central Excise Officer had to determine the amount of service tax due within 1 year from the date of the notice, where it is possible to do so in respect of cases falling under proviso to subsection 1 or the proviso to subsection 4A. This court duly takes note of that by an order dated 26/4/2024, the respondents have been directed to file their response, and in the meantime, further directed not to take any coercive action against the petitioner in respect to the impugned order. However, till date, no affidavit has been filed in that regard. Under such circumstances, this court fixes the matter again on 6th of September 2024. The respondents are given the liberty to file their affidavit on or before 30th of August 2024. The petitioners, if so advised, would be at liberty to file their reply by 5th of September. The interim order passed earlier shall continue till that date.
22.
In this case, Lordship, my Lordship registration has been cancelled. But Lordship, the reason for cancelling my registration is not the reason which has been contemplated under the Lordship. Lordship, may kindly see the reason which has been given in my so-called notice.
Where? In case of voluntary registration, no commencement of business tax within 6 months from the date of registration. Reply, no reply filed. Effective date of AI so and so. Determination of the amount payable pursuant to cancellation. What?
Page 69 says that in case of voluntary registration, non-commencement of business of taxpayer within 6 months from the date of registration. Now, Lordship, on one hand, they are saying that I have not commenced any business within 6 months from the date of registration. But Lordship, I have annexed my Lordship demand notice which they have given for 17/18 and 18/19. If I have not commenced the business from 2017, from the date when the GST had started, how are they giving me 17/18 and 18/19 demand orders, Lordship?
No. What is the reply?
Lordship, I have not submitted the reply, Lordship.
Why?
Lordship, at that point of time, Lordship, what happened? Only 7 days notice has been given. Lordship, may kindly see the notice date. Within 7 working days.
So?
And Lordship, notices, Lordship, along with this notice, Lordship, my GST was suspended. And what they do is that, Lordship, they upload it on the portal. So Lordship, I don't get to see it very regularly. Lordship, you have to issue with you have to always open the portal every time to see. Lordship, it misses it had missed the Lordship. The SSC was not able to see.
So then why didn't you ask for revocation?
Lordship, I had asked for revocation.
Where?
The Lordship, may kindly see my appeal which has been passed, that has been dismissed.
Where?
Lordship, may kindly see at page 72. Status of order, Lordship, rejected. Order under appeal is accepted. This is rejected.
Then?
Page 72. Thereafter, Lordship, that revocation which I have filed, Lordship, they have by way of Lordship, I have filed an additional affidavit. When this Lordship writ petition was filed, after this writ petition was filed, I have given a copy of the writ petition to the Lordship respondent authorities. They have passed this order. In this order, Lordship, they are just saying that we drop the proceedings. They have accepted the fact that in the additional affidavit, Lordship, page 9. They have accepted that they have wrongly issued the SOPOS notice.
So nothing means.
Lordship, the order has to go. Lordship, they have not set aside the order. Without setting aside the order, Lordship, just they have passed this order. That is the only grievance, Lordship, left now in this case.
So nothing, Mr. Gugoi.
This case.
The instant writ petition heard Ms. N. Haveli, the learned counsel appearing on behalf of the petitioner. Mr.
Already revoked.
But anyway, she needs a finality. Who appears for union? You. And so appears on behalf of the respondent number 1. Mr. B. N. Gogoi appears on behalf of the respondent number 2. And Mr. B. Gogoi appears on behalf of the respondent number 3 to 5. The petitioner herein have approached this court challenging the order of cancellation of registration of the petitioner by an order dated 31/12/2019. It is seen that pursuant to the cancellation of the registration, the petitioner approached the appellate forum for the purpose of revocation of the order of cancellation of the registration, which was, however, rejected. Subsequent thereto, the instant writ petition was filed. This court, while entertaining the writ petition on 27/6/2024, sought for certain instructions, issued notice and sought for certain instructions. Thereupon, by an order dated 3/7/2024, the respondent number 3, 4, who is he?
He is not a respondent.
The Assistant Commissioner of State Tax had dropped the proceedings for cancellation of registration and the suspension of registration, which was done effective from 3/7, stood revoked with effect from 3/7/2024. Mr. B. Gogoi, appearing on behalf of the state respondent, submits that in view of the order dated 3/7/2024, nothing further remains in the instant writ petition. On the other hand, Ms. Haveli, the learned counsel, appearing on behalf of the petitioner, submits that the order dated 3/7/2024 does not clearly say that the revocation of the cancellation of the registration have been revoked, and that the cancellation of the registration have been revoked. This court, taking into account the submission of Mr. B. Gogoi and also taking into account the order dated 3/7/2024, deems that the order which have been impugned in the instant proceedings is no longer in existence. And the cancellation of the registration of the petitioner have been revoked. With the above observations, the petition stands.
Now, my lord, whatever return is required to be paid, to be submitted, he must do that one. Because from 2019, that or something maybe there.
That will lordship, according to.
The petitioners
As per law.
shall now
Take steps.
duly file all the returns as per the mandate of law.
Much okay.
Yes, what is this? Oh, this one. You wanted to take time. I said the GST or the income tax department, they are very good in taking time. Why do you take that claim on you?
Lordship, here they have challenged notices under section 148A.
Then 148?
It was a statement of some amount, Lordship. They said that some exemption was that they are seeking some exemption. Like the department, they are not entitled to that. Page 50 is the detail.
This is one step prior to 148A notice. Then what is the thing to challenge?
Their basic challenge is that the notice was not as per law. And secondly, the notice was issued by JOC. And the section 151, it is to be faceless. But as per our submission, Lordship, there is no distinction between faceless and notice issued by the JO. The notice issued by the JO, there is no distinction. It can be issued because this was issued online. Through email, it was sent to them. But in prayer, they have not made such type of prayer. In prayer, they are challenging issuance of notice under 148.
A notice, this came into effect from 1/4/2021. Earlier it was not there.
It was not.
Earlier to directly you go for a 149 notice.
Yes, sir.
And then you do in terms of 148.
Here they are
Now there is an additional opportunity that we want to go for a 148.
you file your
Why do you want to? Why are you not filing objection there?
Lordship, they filed objection that was rejected.
Rejected.
Yes.
Then
Lordship, page 58, under section 148.
they rejected. Order under AI, it has been rejected. Then what happened?
Then Lordship, page 58, an actually was issued. Page 58.
Page 58. I have the following information in your case or the case of the person in respect of Iman. The income chargeable has escaped in there. Either assess or reassess such income or recoup 5 days from the issue of the return of the prescribed form. Then
This notice has been challenged. They have not filed their return. They rest to this honorable court, the challenge is
return?
not filed.
You have to submit your return, then only we can at all do anything. Why haven't you submitted the return? There's a Supreme Court judgment on that. What is that? DY something or something? What the name? There's a Supreme Court judgment on that. You don't want to file affidavit.
You can file lots, but
no, that is your lookout.
What's we decide without affidavit because this is a law point and already matter is decided.
Mr. S.C. Kyle, the learned counsel appearing on behalf of the Income Tax Department submits that the issue involved in the instant proceeding is purely on a law point. And as such, there would not be any necessity of filing any affidavit. He, however, submits that there is an interim order pending, interim order, and as such, an early disposal of the matter is required. Taking into account the above, list this matter again on 3rd of September 2024. Okay? On which date an attempt shall be made to dispose of the writ petition. On that day, the learned standing counsel of the Income Tax Department shall also produce the records of records in respect of which the reassessment proceedings are being initiated. Full stop. In the interim order passed earlier shall continue till then.
Four. Order dated 27/6/24 may kindly visit. But private respondents are beneficiary of the impugned order. So the notice has not gone to them because there is no order for issuing notice against them.
No. What is your case?
Hello, this petitioner has bought the land, or 14 leases of land in the year 2001. But there was a, instead of DAG number 107, DAG number 111 was there. So we filed a rectification in the year 2016 and also, my lord, 2024. But, and in all these proceedings for determination of compensation, notices were issued to the petitioners. Your lordship will kindly see page 48.
The matter was referred to the district judge.
District judge, he is
Then?
age. Then after the district judge has passed the order without hearing me, no notice was issued.
Then?
So therefore I came before the
How
court
can you come here? Under 226.
because I was not heard.
Absolutely
as the
no.
affected party.
No writ against a district judge. No writ against the district judge. Nothing doing.
Not district judge, not against the order passed by the district judge under.
Absolutely. Order will only be passed by a district judge. What is the district judge going to do? So what? This is an order passed by the tribunal. There are lots and lots of judgments.
Not since the petitioner was not heard.
Absolutely nothing. No writ against additional district judge.
Petitioner was not heard.
Huh?
Petitioner was not heard. It's a, your lordship will kindly.
Mr.
see this
B.D. Das,
order.
the learned senior counsel, assisted by so-and-so, submits that he may be permitted to withdraw the instant writ petition with the liberty to file an application under Article 227 of the Constitution.
227, that is there, my lord, that.
What?
I'll correct. I understand, my lord, that I was just talking to him, my lord. That was I may be allowed to amend the petition, my lord. I will incorporate 227.
No. Nothing doing. Accordingly, petition stands closed on withdrawal. However, liberty is given to the petitioner to file an application under Article 227 of the Constitution. Because there you don't make all these people a party. Mr. Das, you don't make these people a party. You pass an order wherein you only make that order out there and challenge whoever it is there on the other side.
Private parties has to be made a party. Private parties has to be made.
They will be made a
But
party.
if
That
they
is a
want-
different thing. But
But
not the state has no business out there.
But what I pray, my lord, that since interim order was there, interim order remain effect for at least 10 days.
Interim order passed earlier stands vacated. Yes.
That is not necessary.
Huh?
Not necessary.
Not necessary.
I'll pass
Hey,
the-
last line to say.
Oblige.
Yes, Mr. Arsharma, what is your case?
We are selling the illegal and arbitrary action of the Dhing police, my lord. I've got a piece of land and some fisheries along with it.
Huh?
I've not been able to harvest my fisheries because of the police, the officer in charge of the Dhing police station.
May not be issued directing the thing not to disturb the peaceful enjoyment of the property of the petitioner and not to obstruct the petitioner from accessing her property.
If
Who
any
is
private
disturbing
party is
you?
aggrieved, they may go to the civil court, my lord, but
Who
why
is
is the,
disturbing you?
the officer in charge of the Dhing police station,
This one, number 5.
my lord?
Is the officer in charge.
No, my lord. Number
My
5 is
lord,
the
I
private
am
Who are
party.
you?
Number 5, my lord.
Who is he? Officer
Private
in
party,
charge.
My lord. And private respondent number 5, my lord.
The dispute between you and 5.
Yes, my lord.
Dispute, it is not even a dispute. Now,
Then
this
why you are here?
number 5, now number 5, my lord, number 5 is instigating this police to come to me and dispossess me of my land. When I go to the police station with all my land documents, this is all annexed here. The police says, no, these are all fake documents. You don't enter that land. You don't fish there. Only this respondent number 5 will be allowed to do it. So it is illegal. And if he has a
Yes, police, what are you doing?
If the complaint, he can go to the civil court.
My lord, I may be allowed to.
Wait, I'll hear you later on. First, let me hear why the police is doing this.
It was a civil dispute, Lordship. It is within the, can you see the page 55 of the.
As you admit it to be a civil dispute, the police should not interfere. Chalo, we dispose it of. Saying that as it is a civil dispute, the police shall not interfere with that, the dispute between the petitioner and the respondent number 5.
Another thing is there, my lord.
There is nothing more.
Only one thing I may, though I have not filed in affidavit, I have received the, my lord. What happened, my lord, from the case of the petitioner, it is very clear. Now it is civil dispute. Lordship may observe, my lord, at a glance, my lord. In fact, the petitioner purchased the land from which person has no land, my lord.
Where is the matter?
Lordship may
Thing falls under which
one, my lord.
thing falls under which district judge? Noga. Go to Noga.
That is true, my lord.
Interesting. Heard Mr. R. Sharma, the learned senior counsel, assisted by Mr. P. Fukon. P. Fukon? So and so. The learned counsel for the petitioner, Mr. N. Goswami, appears on behalf of the respondent number 1, 2, 3, and 4. And Mr. So-and-so appears for the respondent number 5. The instant petition has been filed by the petitioner, being aggrieved by the action on the part of the respondent number 4 in disturbing the peaceful enjoyment of the petitioner over his fishery set up in a plot of land measuring 3 bighas, 3 katha, 4 lechas, covered by dag number 110 of patta number 102 of Magulmari, Isam, under Dhing Moja in the district of Nagaon, Assam. Full. It is the case of the petitioner that the respondent number 4 is acting at the behest of the respondent number 5. First, I've heard Mr. R. Sharma, the learned senior counsel, who submits that the respondent number 4 has no business to disturb the possession of the petitioner, that too at the behest of the respondent number 5. On the other hand, Mr. So-and-so, appearing on behalf of the respondent number 5, submits that the petitioner has no semblance of right over the fishery in question.
Yes, my lord.
Does he?
Yes, my lord.
Does he have semblance of right or not?
No, my lord, because
No, that is what. No semblance of right over the land in question, over the fishery, over the land wherein the fishery has been set up. Full stop. He is the instant writ petition is nothing but a motivated writ petition, and the jurisdiction under Article 2 to 6 of the Constitution have been invoked, not with clean hands. Full stop. Taking into account that the allegation made in the instant writ petition pertains to an interference being made by an officer in charge of the Dhing police station, this court specifically made a query with Mr. N. Goswami representing the official respondents. The learned counsel, appearing on behalf of the official respondents, submitted that the dispute between the petitioner and the respondent number 5 being a private dispute, the officer in charge of Dhing police station would not take the question of the respondent number 4 interfering with the possession of interfering with the dispute between the petitioner and the respondent number 5 does not arise. Full stop. Taking into account the said submission made by Mr. N. Goswami, the learned counsel appearing on behalf of the respondent number 4, and also in view of the categorical submissions made by the counsel for the petitioner as well as the respondent number 5, it appears that the dispute between the petitioner and the respondent number 5 is a civil dispute. Under such circumstances, this court directs that the parties, the petitioner and the respondent number 5, can very well settle the disputes in terms as per the provision before any competent court of civil dispute jurisdiction, and further directs the respondent number 4 not to interfere with the said civil dispute. With the above, the instant proceedings and disputes.
My lord, my lord, there are some miscases going in the settlement office. What happened, my lord? Only at my lord. The land belongs to the Haladar Sud. He already sold out all the lands. Subsequently, my lord, the husband of the petitioner, my lord.
At the last line,
Husband of
the
the
observations so made herein shall not affect either the petitioner or the respondent number 5 in any proceedings of civil jurisdiction.
Yes.
26.
Yes, Mr. R.S. Mishra.
Can you tell the last one?
Oh, what is there?
I've got the instruction regarding cancellation of registration. It was cancelled in 2021 after giving due purpose to the petitioner.
Did
now
not
in
furnish and
2024
due tax to the state for more than 6 months. Hence, so-called notice was issued. However, he neither paid the tax nor furnished reply to the for his cancellation. Registration was cancelled on demand as per the provision. Found that the sufficient allowed to rectify his and deposit the tax. That though his registration was cancelled, taking recourse to revive his registration, all depositing the repetition before. Do one thing. File an affidavit. Mr. B. Gogoi, pursuant to the notice issued on 2/8/2024, have placed certain instructions. This court is of the opinion that the said instructions be brought on record by way of an affidavit.
Right.
Accordingly, list the matter on 11th of September 2024.
It will be next week. This issue
Why?
requires to be decided.
Let him suffer more. What he has done. Taken 3 years for the purpose of a year. What is the urgency?
Obligation.
7 orders.
In this case, I don't receive instruction. In this case, I need something.
Platform number 6 may be deleted, my lord.
Huh?
For 6, my lord.
Wait, why these pages are like this? Why the matter has come? No steps have been received by the section for issuance of fresh notice upon respondent number 6.
6 may be deleted, but there is no concern now, my lord. So, my lord,
What is the matter about?
petitioner's land, my lord, falls under market, my lord.
Ah.
Petitioner pays before the authority to demarcate the land, thereafter go for settlement, my lord. And the state executive officer direct the cycle officer to demarcate the land, my lord. Pays, my lord, 66 penalty, my lord.
The learned counsel appearing on behalf of the petitioner submits that the name of the respondent number 6 may be struck off. In view of that submission, the name of the respondent number 6 is struck off at the risk of the petitioner. In that view of the matter, the service upon all the other respondents are duly complete. Accordingly, list the matter for admission. Huh? No. Thereafter.
After 1 week, my lord.
Admission by on such state the admission after, I'll fix a date, on 21st of August.
28.
My lord, circle officer has already passed the order, my lord. That is the requirement. Copy now. Page 11 and 12, my lord, the order passed by the circle officer.
What is that order?
My lord,
Without expressing an opinion on the merits of the case, projected demand insofar as the claim of the petitioner over the land in this represent disposed of by providing the respondent number 3 may examine the representation. That is it.
Lordship.
Submitted by and take appropriate action in the matter.
Lordship.
Oh, it came up before me.
Yes, my
I
lord, passed
see. Okay, okay.
order.
You have passed the order.
Order is passed, my lord, your lordship, in that
The
11 and 12.
Miss Yuda, the learned counsel appearing on behalf of the respondents herein, have submitted that the circle officer Guri
My lord.
have passed the order on
My lord, on
on
24
26/12/2000, 24/1/2024.
my lord. Last order, my lord.
24/1/2024.
My lord.
Full stop. Now, in that view of the matter, the instant full stop, and in that regard, have placed before this court a set of instructions showing that there has been due compliance to the order passed by this court dated 21/8/2023, passed in WPC number 4688/2023. Taking into account the above, this court closes the instant contempt proceedings. However, it is observed that if the petitioner is aggrieved by the order so passed, the petitioner would always be at liberty to assail the same in accordance
I
with
have
law.
served one copy also.
Okay. The instructions so placed is kept on record and marked with the letter X.
Obliged, man.
Contempt proceedings stands dropped.
Lodge my court order, my lord. Item 59, my lord, service is shown to be incomplete. So, in 59, my lord, I may be allowed to take this step.
Wait. So big file. What are these?
But here the matter is, my lord, the petitioners. They are the investor under the Shara group of
It
companies.
appears that the previous Lozima by the order director appears to take steps for service of notice upon respondent number 2 and 4 by register. Yes. Why do you, who mentioned the matter?
But, item number 30, after being listed for admission, for admission, actually I mentioned.
I
for
am
admission.
saying about 5269.
My
What
lord,
is the matter about?
This is a connected matter, so my lord, it was also mentioned.
Service is complete.
In 30, item 30, my lord, service is complete.
30 means which item?
Accepted, my lord.
Huh?
This is
4183.
418.
What is the matter about?
The matters are here, my lord, the petitioners, they are the investor under the Shara group of companies. Shara India, my lord.
Ah,
Their assets were, my lord, taken over by the SEBI. Still, my lord, as per the Supreme Court direction in a writ petition, my lord, Supreme Court directed the central register of cooperative societies to release the fund of the investor, my lord. So as per direction of the Honorable Supreme Court, my lord, the SEBI, my lord, handed over the fund.
no, then there is some service problem with this. Who is appearing for this Priyanka Prasad? Writ petition.
For petitioner, I'm the petitioner.
5269.
Yes.
There's some service problem. As such service has been completed. As far as 2 and 4, service is not complete. I can't take up those matters.
I'll take a praise system.
Huh?
In Priyanka Prasad, I'll take a praise system.
Then
Subsequent, my lord, the
2 and 4, Central Register of Cooperative Societies, Delhi and Sahara, yeah. And that one, service is complete. But why both of matters are coming together?
similarly, my lord.
So, is it tagged by any order?
Yes, segment.
So then I can't do anything. It appears from the order of the Lozima Court dated 37/2024 that the service upon the respondent number 2 and 4 is yet to be effected. So taking into account the above, the petitioner is directed to take fresh steps by way of registered as well as usual upon the respondent number 2 and 4 within 3 days. List the matter again on 18th of September.
Right.
So it is further made clear if the service is duly effected, both the matters be listed on the 18th of September for admission.
All right.
Great visual. Office note dated 31/7/2024 that the steps were taken. Was done with respect of correspondence 1 to 5. Office note dated 31/7/2000. Steps were taken. Lordship is directed to take the steps.
Service not complete.
Not complete.
The service being not complete, leave the matters after completion of service.
Hello.
32.
As per last order, further hearing was.
Yes, what is this?
Few lordship on a limited ground lordship.
The limited ground was to dismiss it on the last occasion. But why I was not dismissing it, tell me the reason for that.
Lordship, page 18 of the review application is the order.
Page
18.
18, yes.
And lordship paragraph 9.
Huh?
Page 18, then page 24, paragraph 9 of the order.
24.
Comes to page, then page
Yes.
25 lordship.
In the backdrop of the order, this court have heard the learned counsel for as well as the respondent for perusal of the unmotivated the impugned order. It is seen that the same was passed in a whimsical without taking into consideration the fact in its proper. If further transferred from a perusal of the impugned order, this of the respondent was validated the terms still opined the respondent presenting the mohons of the swans, and they got the mohons from recommendation of the husband. Then what happened?
And page 25 lordship.
Is there?
Further to that, even assuming the order had directed that the
Has been
respondent number 7
granted.
and 8 be granted permission.
The respondent number 7 have been granted the permission. Then also such permission has to be understood to be subject to the terms and conditions of the permission, which admittedly had been violated by the respondent number 7 and 8 under such in the opinion. Yes, then?
Then this 29/6/2020, this order, if lordship can kindly take up the writ petition, this order at page 37.
Why?
Because this order dated violation of the order dated 23/9/2002 is in respect of the respondent number 8 only.
You are 7.
I am 7. It is
But
different.
this, otherwise too, it is bad. But then also I gave an additional reason. Whether this reason, if I just set aside that reason also, whether the earlier reasons also become bad.
This minister one lordship.
There were many grounds in my judgment, of which one is I said that even assuming that permission is valid, I said the permission was not valid. I said even assuming the permission is valid, then also you did not comply. Your review petition is that look here, 8 did not comply, I complied.
There is no violation on my part, lordship. Then paragraph 10.
No. I said that the permission is bad. I only say that even assuming that the permission is good, then also, so unless you satisfy me the earlier portion is bad, how can there be a review?
Admittedly, the commendation of minister was there, and page 24.
I can't help you,
There-
Mr. Purkasta, nothing doing.
Percep-
Because unless you say that the first portion is also bad, that my reasoning as regards that without the permission is bad, is also, because I categorically held that the permission is bad.
Their recommendation is also by the MLA lordship, page 24.
Who?
Here, petitioner. Newspaper order has been passed.
No, I didn't ask this to be given to the petitioner. Did I?
No, it is, however,
Would not bar the respondent to take such other decision in respect to the Mohol if otherwise permissible under law.
violation is a little stigma against me, lordship, that I have earlier violated.
So I'll make it clear. Any problem?
Don't have it. My lord,
It's I will only make it clear that the order which has been passed would not be construed to cast any stigma on the review petitioner. Any problem with it?
my lord,
Not you. I mean him. You are a private respondent. No business with you.
stigma means lordship regarding his earlier settlement lordship.
Huh?
Actually, stigma in
No, he got it. He did not, you see, whatever he did it, these are processes by which it happens. So under such circumstances, this order shall not be, the judgment shall not bar the petitioner's case for consideration if otherwise entitled under law.
Oh, yes.
I think that is
As
okay.
per law.
Lahok. The instant review petition heard Mr. S.D. Purkasta, the learned counsel, appearing on behalf of the review petitioner. Mr. P. Sharma appears on behalf of the Fishery
Department.
Fishery Department, Mr. of the Government of Assam, and Mr.
I allow
Suratso
my
appearing on behalf of the
petitioner.
writ petitioner. The instant review petition has been filed taking review of the order dated 4/1/2024, passed in WPC number 4634/2020. The ground alleged in the instant review petition is that the petitioner herein did not violate. Only one is here, na? The petitioner herein, who was the respondent number 7 in the writ proceedings, did not violate any terms and conditions of the permission. And as such, the orders, the judgment and order dated 4/1/2024 is required to be reviewed insofar as interfering with the allotment made in favor of the review petitioner. This court have perused the judgment and order dated 4/1/2024. From a perusal of the said judgment, more particularly at paragraph number 9, it is clear that this court had assigned various reasons for forming the opinion in the said judgment. In addition, also one of such grounds which have been mentioned, one of the such grounds assigned for allowing the petition was allowed, no?
Allowed.
For allowing the allowing the writ petition and thereby disturbing the allotment made in favor of the respondent number 7 and 8 was that
Sorry,
That was set aside, my lord, and
Huh?
disposed of.
It was not allowed
Disposed
lordship.
of.
It was
Disposed of.
Was disposed of. No, for passing the layer, no, thereby interfering with the allotment made in favor of the respondent number 7 and 8 was that even assuming that the permission so granted was a valid permission, then also the respondent number 7 and 8 did not comply with the terms and conditions of the permission. This court further finds it very pertinent to observe that in the said judgment, it was categorically held that the permission so granted by whom? Respondent number 4. Permission
Respondent number settlement officer, my lord.
so granted.
Respondent of 5, my lord.
Who is the respondent number 4? Passed by the man who is the respondent. No, respondent number 4.
4 in the
By permission so granted was also illegal and unauthorized. Under such circumstances, the ground on which the review has been sought for, in the opinion of this court, is not a ground on which a review application can be entertained. This court, Mr. S.D. Purkaister further submits that an observation that there has been illegalities committed by the respondent number 7 and 8, the observations so made in the said judgment dated 4/1/2024, which have been sought to be reviewed to the effect that there were certain illegalities committed by the review petitioner, would affect the review petitioner, in participating in the settlement proceedings. Settlement proceedings of the fishery.
Future settlement.
Huh?
Future settlement.
And future settlement proceedings. And as such, this court may clarify the said aspect to the matter. This court is of the it is seen from the judgment and order dated 4/1/2024 that the order that the said that this court have interfered with the allotment made in favor of the respondent number 7 and 8 of the petition. This court held that the permission so granted by the settlement officer in favor of the respondent number 4 and 7 and 8 of the petition was not in accordance with law. Under such circumstances, these observations, in the opinion of this court, would not bar the petitioner to participate in future settlement, provided the rules of fishery rules do not prohibit.
There is no violation on my part also.
Huh?
There is no violation on my part. Violation of the terms and conditions.
That is not before the.
That is
My
the
lord,
government.
that is not before the.
They have already also participated in the proceeding, my lord, and they have already submitted, my lord, and also a government affidavit also.
Because there is a violation of the part of 8.
If there is a violation of the
These terms and conditions of the.
in addition to that, this court further observes that as the permission so granted in favor of the respondent number 7 and 8 by the respondent number 4 have been held to be bad in law, the question of violation of the said permission would not affect the review petitioner in application of future.
Highly applies.
33.
Lordship, IS civil number 1850.
Yes, what has happened? Affidavit in reply filed. Why is this IA for?
IA for striking out the respondent number 9 and 10.
And an application filed by the applicant with the writ petitioner. Writ petitioner you are
I am the request.
for striking out the name of the respondent number 9 and 10. Full stop. The respondents have no objection to the same. Accordingly, the names of the respondent number 9 and 10 of the accompanying writ petitions stands struck off at the risk of the petitioner. I stands disposed. What is the other one?
Other one is the writ petition 1380. The matters relating to the writ petitioners.
Service complete.
Yeah, already
Yes,
affidavit
sir.
in reply filed.
In view of the striking off of the names of the respondent number 9 and 10, writ petition the service upon all the respondents are complete. Accordingly, list the matter for admission on 30th of August.
Services completed, Lord.
Huh? What is this? Sir, Roy, such a fat file, what is that?
On behalf of respondent number 8, my lord.
Yeah, what are you doing all this? What is this challenge? Roy. Mr. Roy, what do you want in this petition?
Lordship, the respondent number 8, Lordship, he had come to the suit privileges, Lordship. I filed a suit and I filed an injunction application. Injunction was granted. Then, Lordship, thereafter also the respondent number 8, Lordship, he violated, Lordship. And then I filed series of applications before the district commissioner, DGP, police commissioner, Koshi of the concerned PS. Nobody took, and in the meantime, already the private respondent has demolished one. There are three RCC buildings. One building has been already demolished, violating the injunction petition, Lordship. I had no option, then I filed the writ. Then this court passed the interim order, Lordship, directing the police commissioner to enforce the injunction order.
There's an injunction.
Yes.
And you are demolishing.
No, I have not demolished.
Already one building demolished.
On the day of demarcation, one Rajesh Kumar Roy, claiming himself to be the owner of the Schedule E land that is mentioned in the plain of title suit number 95/24, he took the forceful possession, and as on that he is in possession.
No, my lord, absolutely incorrect. That is not correct.
So you have not.
I am not in possession.
Respondent number 8.
I am respondent number 8. I am forcefully evicted from the scheduled premises by one Rajesh Kumar Roy, claiming himself to be the owner of the said land.
Who is Rajesh Kumar Roy?
I do not know. Even he had
Lordship,
mutated.
Rajesh Kumar Roy, he was never in possession, Lordship. He does not have any title, Lordship, and it is the respondent.
And whether Rajesh Kumar Roy is a party in the
No,
suit.
he is not a party, even in the writ petition. And as more as H suit is pending.
And Mr. Ria, what do you have to say in this thing? You must have got some instructions.
Yes.
What does happen?
The private respondent lordship, taking the undertaking from him that he will not construct any demolition of the building lots.
You've taken it.
Yes. 22.5.
My lord, behind the game, Lordship, powerful minister is, he wants to purchase this land. This is a prime land, Lordship, where there were 3 buildings known as Kothari Supermarket. One of the building has been already, we are having video recording where defendant number 8, Lordship has come along with 200 hooligans and demolished the building, middle building, RCC building. Even the DGP, even the Commissioner Police Lordship, they did not take any action.
Why the matter has come up today? Statements made in paragraph of the petition served on so and so. Taking into account that the service is complete, the list of matter for admission on 9th of August 2024. Stop. On the next day, the respondent respondent number 6 and 7 are directed to apprise this court as to who is in possession of where of the building
So Kothari Supermarket. Should property is
mentioned
described
in which land?
Jawahar Nagar, Lordship, Beltona.
I can't say that. No? Building, is this schedule BC?
PCD.
Huh?
PCDE.
There's no E here.
Sorry, BCD.
BCD. Who is in possession of the properties of the building in schedule B, C, and D. The report be submitted on the next date. Interim order passed earlier shall continue. Yeah.
Respondent number 5 has appeared. 6.
Lordship, we have filed the Wakalanam on behalf of respondent 6 yesterday.
And service is completed.
Service is complete. List the matter again on. You got an interim order?
4 weeks time may be given so that we can file the reply.
Circle officer's order is stayed. You got have an interim order. List the matter again on 28th of September 2024. Stop. Interim order passed earlier shall continue in the next week. Hi, Bottakur, what do you have to say?
Lordship, this is a petition for a direction to the authorities to conduct elections to agriculture market committees as required by agriculture. Assam Agriculture Produce Market Act 1972, Lordship.
Yes, why you are not holding? There's some matter which came up recently. Is that same now? You are not being able to do that election thing. Is this the matter? No.
This is another matter, Lordship.
Another matter. You are not in a position to make the voters list.
Lordship, due to the Panchayat election, members of Panchayat is required, Lordship.
Huh?
Members of the Panchayat is required for holding the election, Lordship. But in this case, the petitioner challenged the order of the Secretary of Agriculture Department. Secretary of Agriculture Department, Lordship.
For what?
Lordship, what happened, the petitioner filed some application before the authority for extension of his term of the chairman of the Guwahati Sub-Division Market Committee. That was rejected by the impugn order dated page 26, Lordship. Because Lordship, the first the meeting held on 19 to 2018, the 3 years tenure expired on 19 to 2021, and extended period also expired, Lordship. And then we, the marketing board.
Now you have no board.
As on that, we have no board. The agriculture department appoint the ad hoc chairman. The Department of Agriculture already appoint the district agriculture officer as the ad hoc chairman.
Okay. Why the matter has come up for orders today?
As per the rule 983, we the marketing board already notified the election authority.
Please respond number 6.
This is the Assam State Warehousing Corporation.
Where service not complete. Others are appearing.
I am for 3 and 4.
I'm for 1 and 2.
He is for 1 and 2.
Others are appearing. 6 is there. I think this person is this Kanhaya Gupta or something. Anyways, he was appearing. Anyways, it is seen from the records that the service upon the respondent number 6 is not complete. List the matter after completion of service. Liberty given to the petitioner to take steps by way of the state, routed through the registry of court and file an affidavit of service. So, if such application, such affidavit is filed, the matter be listed with the petitioner, however, is given the liberty to effect service upon the respondent number 6 by way of the state, routed through the registry of this court and file an affidavit of service. Upon filing such affidavit of service, the petitioner would be at liberty to mention the matter for listing.
We haven't paid because we had paid for also extension of the committee.
Understood. Earlier it was not granted. So therefore I am giving you that scope of dusty. Affect it and then mention it. What more can I give you?
Also, the petitioner illegally occupied the government vehicle. After this one.
You know what to do.
37.
Yes. Oh, this matter. Anand Jalpan.
I'm appearing for 4, 5, and 6 private respondents. Who is
Where
the
is
owner
this,
of the particular plot of land?
Yes. I asked the Planning Council GMC to produce something. Likely to produce on the next returnable date the notice which was issued to the respondent number 4, 5, and 6 as stated in the order.
That notice I'm having at present.
What action did you do? What action did you take when a notice you have received?
I am the landlord and he is the tenant. So there are several disputes going on at present between landlord and the tenant. In fact, I have filed one injunction petition in the Court of Learned Civil Judge number 1, wherein the suit for eviction is pending. Now, since in that suit no prayer for mandatory injunction was there, my injunction petition was rejected. Why I filed that injunction petition, my lord? Because he is unauthorizedly constructing, going on constructing over my plot of land.
He's constructing?
He has constructed. For stopping that, I filed an injunction petition, my lord.
Oh. Then?
Then that was rejected, my lord, because no mandatory injunction prayer was there in the main suit. Because it was only a suit for eviction.
And at your instance, this was given. Action was taken.
No. My instance, because if your lordship kindly peruses 4/11/23 letter, specifically it is written, a letter has been received from Dilip Deka, somebody else, my lord.
Where?
Just I have given your lordship the first page, 4/11/2023. First
Then what
line.
did you do?
My lord, in the second page, your lordship will find.
I do admit that I am a co-owner of the plot of land jointly with my so and the company. Sir, we have not obtained any building permission, no objection certificates. Hence, we do not have any approved plan. Then
this letter your lordship wanted from the municipal authority. This is the letter of 24/1.
where you have carried out construction. What did you do?
No, I could not do anything, my lord, because he is in possession. I am the landlord. He is the tenant. He has been constructing over the land. Because I did not have any occasion to obtain any permission, because in the year 2014, I purchased that particular plot of land. And before that, he was occupied because he was tenant of the earlier owner from which I purchased that property. He has been holding that property before I purchased that property. So I had no occasion to, my lord, obtain to carry out any construction or to obtain any permission from the authority. That is only my stand.
Use your sale deed. Whether there is any house sold with your land, whether any land was sold or the house was sold.
So far, my instruction is concerned, temporary shade was there. My lord, I'll produce it.
Much time?
1 week time. Whether, my lord, if
the respondent number, the private respondents, number 456 is represented by
M.
Chaudhary, the learned counsel. However, today none appears on behalf of the PMC. The learned counsel appearing on the behalf of the respondent number 5 and 6 have produced the documents, certain documents. These documents, in the opinion of the court, but to be brought on the filing an affidavit. Again on August 2020. In the meantime, the petitioner are directed to file their same order passed.
I'll file a detailed affidavit.
Yes, some difficulty. Can you print fast?
That you file your reply by, can you file your reply by 16? File the reply by 16. The petitioner, if so advised, would be at liberty to file the reply. Right. Affidavit. By 21st.
Our question.
Interim order posterior shall continue. You produce the sale deed. So the sale deed
I'll file a detailed affidavit. Along with that, I'll also produce the sale deed.